Good morning or good afternoon, depending where you're at. Donna does due process. The Meddler goes to court. We are day 8. Let's get rolling immediately. I am Bob Mata, your host. This is Defense Diaries. And we're going to find out today whether or not Donna Adelson, that gal right there,
I'm not accusing the state attorney's office of
is going to
doing it.
testify.
I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in under Sheriff Google, however, at this point in time, this does not invoke the court to need to go through an inquiry. The witnesses that you're referring to, have they been disclosed to the state?
Not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the sheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not as witnesses, there's not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules.
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things.
True story.
There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you.
All right. It sounds like at least the defense is alleging some shenanigans went on, that there was somebody in the jail that they were planning on calling another person potentially to.
Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of the trial.
Yeah.
That part of it.
Get on.
Again, these are certain things
Miss you.
I cannot assist with. The Sheriff Google, please raise your right hand, sir. Do you swear or affirm
What
to testify
in the fuck
Yes, sir.
is her defense team
You
doing?
just stand in front of the court reporter instead of taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that
Court's as loud as it can go.
may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who has spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Addison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily.
Yeah.
If she did not want to speak to them, they would have to have a subpoena to compel her to speak.
Yeah.
So I
True
after
and
speaking
true.
with General Counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
An examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served.
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
Sheriff Google, there is no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
All right, real quick pause to get Allie up to date. Sounds like after testimony yesterday that there was a correctional officer named Franklin, who sounds like is a female. They wanted to speak with her, so they were heading over to the jail. She caught wind of it. She went to her superior. She's like, do I have to, like, the defense is coming over here. Do I have to talk to these people? Sounds like he gave her the correct information. He went to general counsel. They said, look, you can speak with them. You don't have to speak with them unless you're under subpoena. This defense team, of course, is coming at the 11th hour, literally at the 11th hour, with a new witness that had not been disclosed to the state, that was not on the witness list. The judge is like, I can't do shit with this. Like, you're acting like I can just haul people into court willy-nilly. You have to have a subpoena. And again, the problem is, counsel, that you haven't done your job, that we're in the middle of trial.
Wasn't something like, we just found out this person exists in the world, like something,
I mean, like, how could that be?
I don't know.
I mean, unless it arose, I don't remember hearing the name of CO Franklin, Correctional Officer Franklin, yesterday during any of the testimony.
Well, we weren't riveted with all of it to every second.
Right, because that was the long video play. So that was the only cop that they put on yesterday, and he was from, I think he was from the Leon County Sheriff's Department. So I don't know who that guy would have spoken to. So at any rate, there was an implication by the defense this morning that somebody told this CO Franklin that it would not be in her best interest to testify on behalf of the defense. So there's some implied threat, allegedly, that occurred. And that's where it's at. So he's obviously telling the paralegal here to what would be Donna's left, okay, get the subpoena done and go try to serve her. So that's where we're at. That's all we know. We have no idea what this person would be testifying to, but we'll see how it plays out, I guess. But the judge, there's not shit the judge can do. He doesn't have jurisdiction over just everybody in the world. Can't haul people into court. It's not how this shit works. Sounds like some, more last minute wrangling. And look, I mean, things can pop up during a trial. Witnesses can appear that you didn't have knowledge of. I mean, it happened.
Donna could have gotten back to the prison, and she got word through the prison pipeline that
Jail.
something.
Yeah. Hey, Donna, listen, this is what we heard. This is the word on the street. And then, but it sounds like this all took place from when they ended court yesterday, which was 2:45-ish,
Mm-hmm.
and then before 5.
He can grant a continuance.
Well, yeah, that's not happening.
Well, if they made an offer of proof that this woman knew something so significant that it wasn't their fault, that they could not have known of her before, then he sure as fuck should give a continuance.
I mean, if this
Not
woman,
like delayed, not like trial is this trial's scratched
a couple
continuance.
hours, few hours,
No, a day even if you had to.
Few hours. You give a
Well,
few
he's
hours.
gotta give a few
let them
hours.
scramble. I mean, that's usually what judges do in this situation. We don't get days. Like
You could
we've
get a
had
day.
it.
I've
We get
seen
a-
the state not be able to find
Oh, well, that's the state.
right. So
Yeah.
when their witness up and disappears, goes on the lam, tries not to be found,
like
they
a
get a
fart in the
day.
wind.
Yeah.
That's the state, though. You know this shit's not fair.
What a kerfuckle.
What a kerfuckle.
Concerning the other witness, who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor. Judge, the information that we provided to Your Honor was purely to put it on the record that we had followed that
It's on the
information.
record.
After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
Wait, what?
Right,
Which
as to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as a part of the case?
There you are.
As to the guard, if you need to follow up with a subpoena for this individual, if they have chosen not to speak with you, you need to do so with all haste.
All haste.
Jurors at the time of selection were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
Not even close to 3
And I
weeks.
apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call
look at her face.
Kristen Adelson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon.
This afternoon is up in the air, and that's going to require some additional conversations with our client.
Oh,
During the
Donna.
lunch break, that would be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it will be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying.
That's it.
Yes, sir.
Please bring the
Shit
jurors.
or get off the pot.
And Your Honor, I know that 3 of the witnesses are here. Mr. Scalzo's flight does not arrive until a little after
10 o'clock is
Yes, sir.
Oh, damn. Jack asked me to send you guys the coffee, send him our coffee order, and then I forgot.
Holy smokes.
Oh, what a bad wife. Hold on.
neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
Your order's in, babe.
Did you put it in? What a gal. What a gal. What a gal. See, you never get a clean trial where there's not some kind of crazy shit going on.
All rise, you're entering the courtroom.
Judge Everett, though. We got it in, Brooklyn. We got it in. Welcome, Pose Raven. Oh, family hug. All right, I put the extra boost on. I might be able to pull it off. I don't know if it got any better.
Good morning, members of the jury. Good morning. Everyone can be seated. We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor. The defense will call Kristen Adelson.
Welcome, Poe. Oh, you already said this.
I did.
Poe's Raven. Oh, like it. Oh, I can give the dog his medicine.
Aw.
I'll be right back.
Yeah, for the record, I properly diagnosed the guy with a cough. Missed my calling. Should have been a vet. Nailed it.
Please raise your right hand. Good morning. Do you swear or affirm the testimony you will give today will be the truth? You may take your seat. You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adelson.
And Ms. Adelson, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law and I have done so for 37 years.
How long have you been practicing?
37 years.
Jackass.
Are you board certified?
Yes, I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleague in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again, where I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the Executive Council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
Hi, fella.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
In your work as a family law attorney, did you have occasion to represent Wendi Adelson?
I did represent Wendi Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case, because unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that. And that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Yep.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, they're not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And another one that I have right now is a person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here.
Let's talk about all your divorce
it's
cases.
almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to be close to my parents. It's a very common thing for people to want to move to be near their parents.
Yeah.
No matter how old they are.
True.
Do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do.
She's an expert
I
in
usually
divorce.
let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood. Now, you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot.
This is
at
such
best.
important
Sometimes a little
testimony.
bit more, sometimes less.
Did you
I
have
mean,
that conversation
why
with
do they
Wendi
think this
Adelson
is-
while you were representing her?
I did.
Okay. And did you?
Guess what? I could give a fuck less. Donna really wanted her kids to move closer, and Wendi really
Grandkids.
wanted them to move closer, and the judge denied it, and it wasn't gonna happen. So I could give a shit less that it was otherwise amicable, that it wasn't that big of a deal, that it wasn't such a hard divorce. It's just like every other divorce. Well, these people don't take just like other divorce news very well, do they?
Mm.
But,
Mm-mm.
but I mean, dude, step up your case.
Listen,
Step up your case.
listen. They don't have anything they can do. I mean, sometimes in life, as a defense attorney, you're handed a big pile of shit as a case, and there's no way to shine that turd.
I don't know.
know?
Let's see what the people think. Is it helpful for you to know
Well,
Well,
after
this-
you just gave your rant diatribe, everybody's just say, "Fuck no, Allie's right." I'll make the poll though.
No. I mean, we could ask the people in the chat here. And people love to have a different opinion. They'll be like, "Hell, Allison's talking shit."
Why are you talking shit?
Brandy Gay says, "No
I mean,
no way to shine that turd." Bob always says, that.
Right? Because I mean, the problem is, unless Wendi is waived privilege, she can't talk about anything that was discussed with her client. You know,
Nope.
so she's pretty limited. It's like,
Yep.
is it going to be just general propositions like you're talking about? Like, yeah, divorce is not, it's
It's not
not a
pretty.
friendly occurrence, but
But
like,
I mean, it happens in all my other ones, and no one dies. I'm telling you, no one dies.
no one is hiring a fucking hitman to kill. I mean, get out of here. It's crazy.
Advise her of that same information.
I did. Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relook it afterwards, you're probably not going to win unless something really substantial comes up and changes it.
Yeah.
So if she wanted
like
to
the
try to be able
murder
to
of the
relocate, this
father.
was her shot at it at best.
So in other words, is it
They knew they had no other option.
not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Now, the standard for a modification, what is that?
Standard for a modification
So
is
it
a
was
substantial
impossible.
change in
So they
circumstance.
had no
And at
choice.
the time that I had Wendy's case, there was also another component which no longer exists. But at the time that I had Wendy's case, you
was
had to
another
prove there
hurdle.
was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. That detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendi Adelson, if she wanted to try relocation, she should do it at the front end?
Yes. Proving
That doesn't
detriment
work.
is
Wait, she said two different things. First, she said it was detrimental to the children to modify. And then at the end, she said, which is no longer the law there apparently, that it would be detrimental to the children not to modify.
I think that's what she meant.
Okay, well, she said two different things.
Well, yeah, I don't see how saying how impossible it was going to be after it was denied, how absolutely impossible. I mean, it's not happening.
It's over. Like once it's
helpful to the
denied, it
defense.
is over. You're stuck like Chuck with wherever the hell you're living. That's it
Unless,
until your kids are 18. Then you can do whatever the
unless,
hell, unless you hire a hitman and
right.
kill your ex. Then
Then you've got-
but when you do that, some shit can go down.
yeah, shit can
Things
go
can
sideways.
Things could take a turn.
Yeah, not to
hard
mention
describe
the
to
detriment
clients
to the
because
kids.
they don't understand how substantial that really has to be. It has to be
So substantial.
very substantial. Children are failing in school. Children are potentially being neglected or
I mean,
abused, or there's
bad.
alcohol or drug or mental illness.
Yeah.
We're buckled down and staying.
Have
put.
you ever been
This is so
successful in
helpful to
convincing a
me.
judge to grant relocation?
I personally have only won one case in 37 years for relocation.
Oh my God, why is this
So-
helping?
Would you say it's difficult?
I think it's difficult.
They just want them to know they always knew it was difficult. and they
Now,
didn't-
even though
they-
you've
this
only
wasn't planned.
gotten court approval for one with a client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases.
All right, so this is the $1 million bribe. They're going to try to address the $1 million bribe concept. That just at least letting the jury know that look,
That's normal.
sometimes financial issues can help resolve, or financial, like an offer for money to be paid to one of the parties can help negotiate these things. But like she said, I mean, the reality is relocation is typically going in front of the judge. Like you can almost always negotiate everything else in terms of a settlement agreement. removal is not one of those things, because if you've got one of the parents that's like, I'm not letting you take my children 6 hours away from me, go fuck yourself. It's
Right.
not happening. Then, which is what we had here.
Sometimes through help
But I
of
think you're
mental health professionals who will
I was just gonna say, I think that's probably their whole point here, maybe, is to get to the fact that she's saying it's a bribe, but it's really just,
Well, that's what I just said. It's
I
like
think
there's
that
nothing shady about that. It's
right.
like it's not a bribe. You're trying
It's
to,
the same thing. It's just the word, but
but
the state
the
does make a
bribe
big
has a
deal.
very ugly connotation to it.
Right. And the state does make a big deal about it being a bribe. But geez, hammering away at like a word here.
Well, I mean, if you can address the $1 million thing, because I mean, in the scope of the state's theory, it's a significant thing. It's like, oh, well, they tried the court thing and then they were going to try the money thing. And if the jury can hear, well, number one, the money thing's not illegal. It's like bribe gives a
Right.
illegal connotation. And this isn't illegal if you're trying to negotiate a financial payment from one party to the other in order to get this thing to happen.
I
There's
just think
there's nothing untoward about it.
I just don't think the jury's stupid enough just because Donna used the word bribe to actually think that it's something, yeah, and like people are saying in the chat here, like it's an incentive, it's negotiation. Like I
Right.
think they've been through divorces. They know, like she's saying bribe, but we know that that's just part of it. I don't think they're stupid enough to actually.
Well, you're assuming that everybody knows how the system works. I mean, that there could absolutely be jurors that are of the mindset, okay, she was trying to pay him off, which is illegal. So I disagree. I think that there's plenty of people that don't have any idea how the system works, including, not only the criminal justice system, but the family law system is, unless you've gone through it, you probably have no fucking idea, So
Yeah.
I mean, is this winning the case? No, but is it one of those things, what I was talking about yesterday, that they're trying to poke little holes in different parts of the state's theory? That's all they could do,
Yeah.
I mean,
interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister.
Yeah.
She moved to Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And I think you said you explained all of this to Wendi.
I did.
Was she aware that the chances of success were low?
Yes. I mean, I told her that this was her shot. I thought she had some good reasons. I would never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it for many reasons. But including the fact that her parents were down there, that Professor Markel had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about the family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the The parties and lawyers and their paralegals help them fill out. We also have to provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with
Voluminous.
the other
Right.
Luminous.
counsel.
And when
Voluminous.
completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns. So you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on the financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits. And I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow. So you're entitled to the growth on it too as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court at least.
Now, I want to back up a little bit. What happened with Wendi Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendi Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that. And then at the end of our testimony, the judge asked to speak to counsel, which happens a lot. And she took counsel out It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to move, but she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendi go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendi about that, and then Wendi's parents were there, and I actually spoke to Wendi and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendi ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013.
Yes.
Okay. And what was Wendi's reaction?
At that point in time, I think she was upset that she wasn't going to. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendi Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past
Now,
and since that time as well.
Subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did. And at that mediation, we came very close to settling it, and we were there for quite a long period of time, but we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
And
subsequent.
before we had a court hearing trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was the, if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion. And then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also an exception about what happens in mediation if the marital settlement agreement is
All right, don't do it again.
It's the best. It's the best.
Maybe she's gonna
set
wait,
aside for
Oh,
some
sorry.
purpose.
and it's still going in my ear.
Yeah, I mean,
I'd like
just like
it
the
to
testimony.
stop now. It's too early. On the loop, it would have been all right once. So I was gonna say that, hopefully she's gonna get into how unlikely Charlie's petition was. Like that thing didn't have a snowball chance in hell. Not anyone was worried about it. I told them, no way, no how, not helping, not happening. Grandma's going to keep all her rights. Grandma's going to see her kid.
Oh, you mean
Never.
Dan's petition?
Yeah, what did I say? Charlie's?
Charlie.
Wow.
Charlie says, got my good and plenty.
Big and-
Charlie
yeah.
says, all right, you ready?
I'm ready.
You're ready.
It's like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore. And Professor Markel is not with us anymore. So a lot of people in that mediation are gone. And Ms. Adelson has waived confidentiality.
You can just punch Ms. Edison. With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all subjects as well. You may continue.
Thank you very much, Your Honor. Ms. Adamson, can you tell us that Charles Schwab account that you mentioned, how was that addressed at mediation?
All subjects.
So this became sort of a last minute little dust up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation. And I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined, in his opinion, what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple counts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement.
What is so important about this Charles Schwab account?
He had almost $500,000 worth of non-marital Charles Schwab accounts of his own. So he had non-marital money as well.
So based
You
on
need
what
your
you've
stinking money.
discussed, Mr. Markel was aware of the non-marital status of that portion of Wendi Adelson's portion of what she would get.
He was.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
Shortly after the divorce was final, did Wendi invite you to a get her groove back party?
I
Yeah.
don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendi Gets Her Groove Back.
Wendi Gets Her
And I had
Groove Back.
several friends I knew of Wendy's that were there as well. And it was just sort of a Wendy's
Divorce
in a good
party.
place. Come celebrate my new life party. Yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions.
She's like,
We
"Don't-
had 2
don't-"
mediations.
I mean, I did a lot of work. Here
Um,
it comes.
One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
Well, that's not bad.
And costs of?
That includes costs and everything, I think.
Go hire her.
Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
now litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, subsequent, did the marital settlement agreement require that Mr. Markel pay Wendi and yourself certain sums?
So according to the marital settlement agreement, Professor Markel kept the house. So he was supposed to pay Wendi for her part of the house. And all the other assets were divided equally so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. he had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendi did. And it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendi did. So that was part of the agreement. He was supposed to pay me $10,000. He was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st.
I think that's right.
Did Mr. Markel pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendi, the money. He gave her $50,000 of the 120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markel was going to pay.
Did he pay?
He did not.
What did Wendi ask you to do to enforce that?
Hire a
At
hitman.
some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he's owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier if people will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money, and I asked for a court hearing on all of that.
Sounds like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Did that prompt Mr. Markel to pay?
No, it did not.
What happened?
So then Mr. Markel hired a new lawyer. And his new lawyer filed a responsive pleading to that my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first responses and motions, this first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money,
Well, you
and that
can't
she
hide
hadn't
something
told
you know.
him about several other of her retirement accounts, and therefore the marital settlement agreement was breached, and he shouldn't have to pay her the money.
So he filed a response, but did he
Look, even that lady's
seek to
yelling.
have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendi at the time,
Made me
is
yell.
that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous.
I use footnotes.
And it was very personal about what was going on and Wendi and how I don't think at this point he alleged that he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for
Baller.
a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
You filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing what he wanted to do. And so
Stick to
I
academics.
then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
In the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendy's part?
I think he filed at least one or two more pleadings that did that.
And before we get to the final one, that you advised Miss Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily
Be right back.
involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response. And I told Wendi that it wasn't, and not to worry about it.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markel and his attorney were attempting to depose Ms. Adelson.
So what happened was I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would
Pending,
happen in
right.
terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition.
Gonna
We went
quash
to
that shit.
court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing.
Yeah, she's just
The
like,
judge
let him
read
put all
of
this
the
in.
pleadings,
I agree,
and she
babe.
said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file an additional pleading concerning complaints that he had about right of first
Donna?
refusal, parenting time, and things of that nature?
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now. about the parenting, and it was that that Wendi wasn't allowing him to FaceTime with his children as much as he wanted to. That he wasn't that they weren't allowed to go to be present at the same birthday parties. That if there was a birthday party that he was at, she wouldn't come, things like that, and that that she wasn't. I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids, and I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time. He also, I think it was that pleading where he went on a little bit more about Wendi and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Okay. Now, the one motion concerning his my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
Kidding.
And what is that?
Kidding.
Well,
Pause
it's
this a
not
sec.
actually
People
a
want it broken up anyway. Did he ask to have her offered as an expert in divorce law?
No, he didn't
And the
tender.
state's just sitting there quiet as a little church mouse.
Yeah, I mean, they haven't objected to relevance
or
at
anything. Like,
yeah, I mean, nothing.
haven't said word one. They're like, all right. I mean, there is not they're like, I feel like they want so much to be said because they're ready for their cross-examination. Because, I mean, we'll have to see if it comes back to bite the defense in the ass. But the judge said that he is compelling her to testify on all things mediation, not just this Schwab account thing.
Yeah.
That was wonderful. Bravo. I loved that. Oh, it was great. Well, it was pretty good. Well, it wasn't bad. Well, there were parts of it that weren't very good, though. It could have been a lot better. I didn't really like it. It was pretty terrible. It was bad. It was awful. It was terrible. Get him away. Hey, boo. Boo. That was wonderful.
Legal term,
Bravo.
and it's
I
not
loved
actually
that.
a recognized mental health term by the mental health professionals. But it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to
Keep them
put
apart.
up roadblocks to parentings. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they've completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use those terms. I've seen it.
Okay. The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No, it's not possible.
Look at
And I
Donna.
told
She's
Wendi
like,
that.
see.
Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. And it was the last one that he filed. I believe it was in May May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very
Man,
personal
not
towards
saying a
me and
word.
said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able prior to withdrawing to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case.
So there you go.
Hearing had to be moved.
They didn't that see,
And
there you go.
around this time, were you aware that Mr.
Pause it.
Markel had to change counsel again as well?
I did not.
So there's a good point, is that this hearing that the state is making it like, and that hearing was never heard. Why? Because Dan Markel was murdered. Is that hearing was already set. It would have been heard long before that. And this whole other thing is just a quinky dink. Just a quinky dink.
Quinky dinking.
Know that.
Had to change
Yeah.
counsel again as well.
I did not know that.
Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he
Jack with my
continued to
coffee?
ask my client to watch
Yeah.
the children during his time
It's
sharing?
around the corner.
The fuck?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendi.
And on that note, we discussed earlier that it's not unusual for parents or families
Look
to
at
be
Wendi.
involved in meetings.
I mean, Donna.
Was
said-
my client, Donna Adelson, involved in any of the meetings that you had with Wendi Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't, even after even afterwards, they were fine. I had no issues with them, but I never spoke to them.
Oh,
I never
this is
emailed with them. I never,
Yeah.
came to any meetings. They were not involved with me.
I'm just anticipating.
And do you have a recollection of whether my
Constitution's
client
cross.
and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Just a moment, Your Honor.
This is high note he's ending on. I think we'll have to see. Defense wants to stand so quiet.
Whoa.
So that
Shocking
cross-
testimony. Shocking testimony. Shocking testimony from Wendi Adelson's former
And-
attorney.
Good morning.
anticipating
So you said you weren't
massive
you weren't
objections
aware
during their
of
cross.
Donna Adelson's
but
involvement.
I could be wrong.
in
She
the-
was not involved with me.
okay.
So no.
Did you know
Oh.
that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings? How about that?
Mm.
I'm not aware of any of that, no.
Okay. Do
Little
you know
does
that
that
she
matter.
was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay.
Are you aware that Donna is a real fucking meddler?
Did Wendy though give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendi on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client. in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you chat GPT and want you to do chat GPT pleadings, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this. That's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendi sending pleadings to her mom and saying, let's edit this.
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendi.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised
Little
when the
dig.
relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that
Well,
time.
I'm always hopeful, but
Right.
And I thought she had a good shot. I wouldn't have let her do
That
it.
fucker
I mean,
came
I'm
back.
not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or
Don't
family
wait, you
members
stay
of
right
clients
there.
who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes,
Okay, even given your best guidance.
yes.
Okay, that's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right, and at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
I've been trying to think about that. I think that that's probably why I had them sit outside, is because they
Right.
could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So
and-
that's right. Yeah.
Okay, so that's why they were in the hallway.
That's why
most
they're in the
likely.
hallway. Yeah.
Okay, not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendi was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendi Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No. Okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure
court.
you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendi, and then briefly, as far as I remember, because I mean, it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, I didn't agree with the judge, but this is the judge and they get to make the decisions. And I think that Wendi went and talked to her parents without me and then came back and said, okay, we're good. We can go into court and we can stipulate.
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face.
No.
Okay. You talked about Dan Markel not paying what he was supposed to pay according to the settlement agreement. In Dan Markel's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact that he was accusing Wendi of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markel held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforce it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying. And then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue. And that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying. And then
could I ask you a different question?
Okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. Would it be just one step? It would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequence is we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money. And then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not.
Dude, I'm like Little Miss
if it was
Muffet over here.
successful, Probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, could he lose his bar license?
Eating for curds and
If
whey.
he's held in contempt of court?
And
Or at
alone
least be in
in a
trouble with the
spider.
bar?
He could. I've had lawyers held in contempt of court over these issues before. But they could. It is a possibility.
Did you inform Wendi Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did, because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendi Adelson?
Sorry, I'm sure I'm distracting everyone.
I don't know if contempt. I can't remember if he actually said should she be held in contempt legally the way that I was using it. I think his pleadings were much more Wendi should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
That she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces
that,
I've had. I mean, we settled,
you know,
I don't
that
settle
last
a lot of my cases, but
petition
we
there.
Go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I
Hey,
really
pause
didn't
it a sec,
understand
babe.
it because he paid the first $50,000 fine.
Just to break up the monotony of it. So, I mean, yeah, Little Miss Muffet, because it's like, and you guys, anyone that was here yesterday, the spider was coming down yesterday. It was coming down like arm's length, like away from me, like right kind of down the side of my computer. This one, I'm looking straight. It's like right fucking here. Okay. So I've got nothing near me to like scoop it with, grab it with. And after my complete failure yesterday because I had like a little something that I tried to grab it with, I just grabbed some toilet paper from I was quick. Fucker was right there.
You
And
should
now-
have blew some vape juice on it. Like you should have vaped it out. Probably would have passed out. Little spider legs up in the air.
I don't know. It's just vapor.
I mean,
Yeah,
I don't know. I think it'll kill a spider.
it's just air.
And then all of a sudden he decided not to pay the rest, and I didn't really get it. and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendi or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is
And
when he did that.
Was that personal attacks on both Wendi Adelson and you?
Correct.
And he was alleging that Wendi Adelson committed fraud, right?
Yes.
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendi Adelson's behalf, right?
Correct. That's happened before, though. I mean, I've
that's
had that
not
happen before.
all that unusual.
And he alleged Wendi should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markel and Wendi Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendi Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not, we've had a few people get murdered, and I've had a few suicides. But
Wow.
it's rare, and I remember all of them.
Right. But not contentious.
Sometimes, I don't know with the suicides, I don't know.
That's all.
Thank you.
Redirect examination.
Briefly, Your Honor.
Yes, please hit that like button. So I can get mint to spray for spiders. Somebody said mint. Just circle back to the fact that hearing was scheduled for before then, and the only reason it wasn't heard.
You may.
Ms. Adelson, I'm going to approach and show you some. I'm
Oh,
sorry.
guys, it was
States demonstrative A, I think it's court exhibit 1, page 441 of the demonstrative. And then I'm holding 454. Can you hold that,
Sure.
please?
Okay.
Is that the March 26, 2014 pleading that Mr. Markel filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's time with the children? Does that reflect that Mr. Markel was asking that my client's unsupervised time with the children
Bob came
not
down to save
interfere
me.
with his right of first refusal?
I think you're talking about paragraph 6, where it says enjoin the former wife from allowing
That's
the maternal
Miss Markel,
grandmother
Mr.
to have
Markel's,
unsupervised
Professor
time with the
Markel's mother.
children, consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Yes, that's Dan's mom. Hey, her and the father seem to be maybe finding solace in one another. They're sitting next to each other. Right? I always felt bad that they didn't have each other
Ms.
to
Adelson,
lean on in these hard
Did-
times
You testified that
in my
the
mind.
divorce was not contentious, but some of his pleadings post-divorce were contentious.
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendi Adelson and yourself.
Correct.
Is that what caused you to withdraw?
No.
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markel not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
In May. You got to say yes in May. That's before the first hit.
Now, after I want to go back to relocation. After the relocation hearing, my client Donna Adelson appeared to accept the court's ruling. To you,
As far as I know,
you don't know what she said privately, do you?
I do not.
Concerning
I'm surprised the prosecution didn't
Wendi
go.
Adelson's
deeper.
involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you.
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts. And then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendi Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendi, I don't remember that Wendi had much input into any of it, honestly. She wasn't that client. I have clients that are those clients.
So
She was
Wendy's
not
like
that client.
uninvolved in her entire
I
divorce,
get a
but
lot
for
of
the
chat
conversations
GPT
with her
now,
mom.
a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am.
He's like, I go through it every day with
Had-
this one over here, the meddler.
Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it
Well,
was
you better
set.
get that date on there,
If the-
sir.
Whatever the docket says for
Pull the
whenever it was
docket and
set.
show
So
it
if the
to her to
docket
refresh her
reflects, I think it
memory.
was May 15th of 2014. The hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
You better
Nothing further.
put the
Will this
actual
witness
docket
be
in.
recalled?
Just a moment. We'll retain
Bob
what
came
she's free to
down.
go about her business.
Thank you.
You may step down. Please call your next witness.
I'm waiting to hear from those two people that were
Sure.
there on the recorded
Next
call.
witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break. Jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hands. A very equivocal wave, but I'll take it. The bailiff will take you to the jury room.
Does anyone know?
10:05.
Can anybody remind me? I don't know. Sleuthy's in here. Maybe she can remind me the name of the two people that were there for like So they're on their jail call. Oh, there's my man. At least and
Hey.
maybe you remember because I brought it up before and we looked it up and now I forget. But what? Milo said the man on the recorded call testified yesterday. Gutterman?
Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. And we'll try to start again at 10:05.
Thank you, Your Honor.
What time? Oh, I forgot. We have some looping.
Wait, so everybody's saying that, so there's the jail call for anyone who doesn't know. I'm pretty sure everybody here's been following, but the jail call between Donna and Charlie, that Charlie disconnects and it's still recording her in her house having this conversation with her two friends.
Oopsies.
So the chat saying that was Gutterman yesterday. The guy with the walker was one of the guys in that conversation. Sorry, hiccup.
What do you mean in that conversation? You mean that was in the room when they were having the discussion in the room between Harvey and Donna?
He's the one that said "au contraire," or he's
Yeah.
Oh no,
He's
the one
Captain.
with
No, he's the guy who said "au contraire."
but there was the Walker guy. There was two different guys, right?
Au contraire.
Yeah, the Walker guy was like gray beard, I think.
Au contraire.
I'm just gonna blame my perimenopause brain. and
Well,
that
I don't
gets
have
me off the hook.
perimenopause,
For Thursday
and I can't remember either. So
I don't
don't beat
remember
yourself
them.
up, babe.
I don't remember them. The guy who said she was just a typical grandmother.
Well, if whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Wendi Daly as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom, whether or not there were any other matters that were discussed along with that. I cannot completely recall at this moment, but we'll review. At a minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
And I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related
Like
to
them
the
to
witness
stop.
yesterday, I gave instruction concerning that. Attorney Ms.
Violated.
Bailey will review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
I mean, the
You
defense.
can let the jurors know I'm going to go to the court reporter's office to check the sidebar. From there, we will finish this matter.
All right. So we had this kerfuffle last time when they had one of their witnesses in the courtroom before they testified. Why is the defense, or at least the damn paralegal, why aren't they telling their witnesses who they're coordinating with to come to court, do not enter the courtroom until we come and get you to? Like, what is wrong with this defense team? All right, it sneaks past you once. Then you're like, okay, we're going to make sure to tell everybody. You know it's paused, right, babe? Maybe he's got a spider. Oh.
Donna, this is your conscience. Tell your lawyers to keep their fucking witnesses out of the courtroom before they testify.
That's fun. That's fun. So, but I don't remember Chagrin man with the tie, man who said she was a typical Jewish grandmother. Did I miss them talking about what he understood that conversation to be about? Or they didn't get into that?
I don't remember them getting into it.
Chat, help us out.
Well, they
Help us
said it
out.
was at a sidebar.
No. We're talking about two different things. I was
Oh.
just saying how I really wanted to hear from those two people that were there. And then the chat tells me, Allie, pull your head out of your ass. The old guy was here yesterday.
Chagrin.
Right. With the
What a
tie.
good name. What a good name. Chagrin. I'm chagrin. Oh, just bring me some Joe Boo.
Tell him to
Bring it
come
on
along the
in.
other side.
Oh. Oh, thanks.
Why don't
Jack.
you have him coming around the other
What a
side? Where
guy.
we can't see
What
him?
a guy. Yes.
The whole world sees you now, Jack.
You're on blast, Jack.
Yep.
You're on blast.
All that witness protection done.
Jack did pretty good. Did pretty good.
That was the longest trip ever.
I mean, you know,
But I
hey,
appreciate it. I appreciate
beggars
it.
can't be choosers. You know
All
what I
right.
mean?
So I just want to talk to Kiki Marie right here.
Kiki Marie.
She watched our Dateline episode last
Wow.
night. Also listening to the replay of yesterday's stream. I love.
Did you
your
get to
give-
that part where Josh Mankiewicz like tries to flame throw me? He's like, so I wanted to ask you, when you were at the bar after closing arguments and you played Sympathy for the Devil, were you saying that your client was the devil? I'm like, what? No, dude. I'm like, all the
That's what it
people think
felt
he's
like.
the devil.
Right. So it felt like we were trying to get sympathy for the devil.
Right.
coming
You know,
through.
it was a cry. It was a cry.
But I was going to touch on, there's a lot of editing, a lot of making it look like things that were being said were at different times. So, for example, where I say, shut the fuck up, that was an
I mean, y'all know
excited.
Allie. That's just like her, talking shit.
Grazie.
Prego.
Yeah, and then they tied it closely with me like throwing garbage in the trash can. That was Angry Alley. So they took, an excited like shut the fuck up to one of our paralegals. No, one of our law school assistants,
Oh
or
yeah.
new lawyer. I can't remember if he was still waiting to pass the bar. I think he had not passed the bar yet, but whatever. And combined it with me being like, why the fuck is the press in here? Ugh! I want the press out of here. They shouldn't be in here to begin with. And made it look like I was like yelling at an expert. Didn't happen.
Yeah, I think that episode's called The Haunted.
Yeah, let's just not watch it because it's lies.
I don't give a shit.
And they don't
I
tell
don't
the
give a
whole story. Like even our son was like, I was
Oh.
watching that and I was
They we know what Dateline does. I mean, people love Dateline, but they go with they go with the winners on that, and they flamethrow the losers on it.
Yeah.
It's on all the time. It was from back in 2016 or 2017, whenever it aired.
They don't tell
But
they
that
don't
that
tell the
part
story.
where my dad's like, Bob, you might not want to swear. And I'm like, fuck it, man. I'm like, they're supposed to be flies on the wall. I'm not changing anything that I do.
And then
But
that's
they're in
probably around the time that I started screaming that they shouldn't be in here to begin with. I don't
Yeah,
like
that
it.
was definitely one of the war room conference rooms.
They were only in there once.
Right. They got a lot of action in there, though.
Yeah.
Our war rooms were no joke. Our war rooms were no joke. All right. So what did they take a break for this time?
Well, he's going to listen to the sidebar. I couldn't tell.
We've got some blooping, which we're
Oh.
going to have to eat up, sadly.
Yeah. I mean, that's why it's there. So he's going to listen to a sidebar of the judge about what the witness can testify about. I think that's wholly independent of the sequestration issue. At first, I thought he's going back to listen to himself tell them don't violate the sequestration order, but I don't think that's it. Sarah Fritz, thank you for your super sticker. Nikki, was Donna's involvement discussed in Charlie Adelson's trial? You aired it. I'm pretty sure it was, right?
Yeah, of course. I mean, Oh. Now the
What?
guy sounds like he's vomiting.
What? He's upstairs?
But this sounds like an actual vomit.
Oh, I'm stuck. I'm coming. Mommy's coming, baby.
Go check him, baby. Poor guy. He's going through it. Sweet, sweet pup. Yeah, I mean, they definitely got into Donna's, because Charlie was the one coming up with the whole extortion, him and Rashi, that whole concept. So obviously, yeah, we heard about the wet money, Donna dropping it off. Yeah, it's definitely discussed. He did? Dude's eating grass again? Grass and wood. Grass and wood. Dogs just eat anything. All right. So I don't know if you guys saw, but there is a wheel going today. It's for a huge, fat sticker package and a signed picture by Nanook, of Nanook, in all his cuteness. You're going to love it. He's going to take his little paw print, stick it right on there, and it'll be yours that you can show your dog. And your dog will be like, oh, can me and that dog be friends? Because that dog looks awesome. Yeah, who doesn't love a fat package? They're the best. The best. Yeah, I mean, he's been doing this coughing thing where it kind of sounds like where he's, he coughs and then it seems like he's gonna gag. But we got some medicine from the vet yesterday. The cough seems better. The medicine might have upset his tum-tum. Allie thinks that's what happened. Well, we knew he eats shit out there all the time. Dude's got like very, very limited ability to be able to not eat anything that he wants. Yeah, our dog too. He's a very friendly guy. He's a face licker though, meaning he's very athletic. So I could have him and I cannot stop him from jumping on people because I don't use like pinch collars and shit. I don't like it. Like I'll never hurt my dog to teach it something. So, like people that know dogs, they know if they bend over and pet him that he won't jump up, but he can jump up. He could lick a 9-foot man's face easily. Like, so, but if people don't know your dog, and if I've got him off leash at a off leash park or like trail system and, he sees a person, he'll run up, he's all excited, and then he will jump. Like I'm always telling the people, I'm like, he's not an aggressive dog. He won't bite you ever, but he will try to lick your face. He loves to give face licks. He's a kisser. He's smooching. Yeah, I don't like. We have like a relatively decent sized yard, but our subdivision does not allow for fences. So there's the invisible fence thing, right? And it's like you're shocking your dog. So it's a real conundrum. It's a real conundrum for me. Like I don't know. So we haven't gotten the invisible fence because it seems cruel to me, but I don't know. You guys tell me, is the invisible fence thing cruel? Seems cruel. I don't know. But he's a runner. Like he's half husky, so like this dude needs to run. Let me see. Yeah, I mean,
Hot from the presses from our very capable court reporter.
All right, here we go. Let's see what's going on.
So hot from the presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, sir.
Please make your argument.
Please make your argument.
Judge, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zolman,
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Y, to be able to observe witnesses. We were not asking for that.
as to both the context and the discussion is concerned, and
Yeah, I try the gentle lead.
listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now. Why should this witness be permitted to testify?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened though is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Miss Bailey to be present during Kristen Adamson's testimony.
Okay, well, you fucking misheard,
And that's
Pinhead.
what we advised the witness when we spoke with her later.
Okay, well, you fucked up.
Pause it.
This conversation, we would not have done that.
All right, so I missed all this. Why is he a pinhead? What did he miss here?
All right, hold on. I'll go back. It's not lengthy. So
Okay.
essentially, there was a conversation at sidebar about whether or not their expert could sit in during another expert's testimony, and Georgia was like, no, they can read the report of the other expert, and like they can't sit in for it. So they weren't agreeable. There was no agreement as to it, and they apparently just didn't really listen to what the judge said. And
So
they,
the judge said they couldn't, because a lot of times your expert can sit in during the other experts. I mean, that's their whole point.
yeah, I mean, but like in this particular circumstance, it was raised. So let's go back and listen.
Well, I don't know that everyone else wanted to hear it again, but
I am agreeing for their experts to review the testimony of other experts and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
oh, lay witnesses.
Mr. Zolman,
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Y, to be able to observe witnesses. We were not asking for that.
as to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adelson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adelson was not an expert.
Mm,
The state never agreed
that's
to
different.
what was being discussed now. Why should this?
So did they allow this witness to sit in the courtroom while
For an adverse expert, yes.
it was
but-
okay, but for their own witnesses, not okay? So
No.
what they're saying is they allowed this person to sit in the courtroom while Adelson was testifying. It sounds like
Right.
somebody that they want to call who now has violated the sequestration order, and it didn't fall under the agreement because it wasn't an adverse witness, meaning that the state didn't call them. So
Yeah.
that's a problem.
He's not going to, he should not exclude it. He should do some other, remedies, but we all,
what is the
anyone
remedy?
anyone
What is the
who's
remedy?
a trial watcher knows the worst thing a judge can do is exclude the defense's witnesses and prevent the defense from presenting a defense, especially when it's going to be based on, I'm just going to say, attorney incompetence. I misunderstood you. So all he can do is either he can advise the jury this witness was not supposed to be in the room, he was in the room, or he can just, which is probably the best, just allow the state to go through and point out that he wasn't supposed to be in the room, and you heard this and you heard that and you heard this, and let it imply that it somehow changed something. But I'd be surprised if he forecloses their witness altogether.
I mean, it's an extreme remedy. There's no
Mhm.
question about it. But what is the alternative?
I just said it. It was either the judge admonishes the jury, this guy should have never been in the room and it violates our thingies and we do this for these reasons, or he just lets the prosecution ask a lot of questions on it. You heard this, you heard that, and let them imply that it somehow altered what he was going to say. That to me is the best remedy. I think even the judge giving too much, it just would be overly prejudicial. Especially if it's not much that could have changed the testimony,
Yeah. All right. Well, let's see what he does.
He's not happy though.
He's not happy. Look at him. Does that look like a happy judge right there? He's like, Zellman, you're fucking up.
You're fucking up.
You're fucking up, Zellman. You keep fucking up in my courtroom, and I'm not happy about it.
Witness be permitted to testify.
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adams' testimony when she testifies.
You brought this up, yes. But the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened though was the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you
There you
recognized
go.
previously. We took the court's, this conversation to authorize Miss Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week.
Well, you can't
But
fucking
for
read, bro.
This conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. Witness was addressed at sidebar. He brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. the case today? Why have you not been more careful with this individual or even brought up this topic to make sure we did not end up in this point and place?
See,
Because I'm
Allie's
incompetent.
100% right. I mean, like, he's not going to punish Donna, meaning she can't have this witness testify because of her lawyer's incompetence
Right,
or
because it would just end up back
sneakiness.
right, it would just end up back in front of him on could. Obviously there's what we call harmless error.
Yeah.
And in a case like this, I don't know. I'm not even sure what this witness is about to testify to, but in most cases, a judge doesn't want to take something that clearly he's even putting on the record. This was your fault. This was your incompetence. This is not right what you did. I mean, he's basically laying all the things down for ineffective assistance of counsel in that regard. Obviously, there are other legals. It's not like everything your lawyer fucks up can get you a new trial. No, 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 no. No, no, no,
Right.
no, no. It has to be would have had a difference on the outcome of the trial. But still, this is something a judge is not going to risk. I don't think, but I mean, we'll see what he's going to do. Risk barring the excluding the witness.
Yeah, and it's a really shitty feeling to be standing in open court where the judge is
Can't.
basically calling you a fucking turd. It's not the first time, it's the second time you fucked up, Mr. Zellman. And like Donna's sitting right there. It's like
And the whole
not a
world's
good
watching.
feeling. Like you don't love that feeling as a lawyer because you're like, oh my God, this sucks.
And now the whole world's watching.
And the whole world's watching. Zellman just shit the bed.
Yep. We need to shit the bed. No, please don't play that soundbite.
Wait, what? Wait,
No,
what?
no.
What? Wait, what are you
It's not a
talking
fart,
about?
it's a shit the bed.
Wait, what are you
I'm gonna
talking
fart
about?
so hard. Oh,
I mean, you asked
Hey,
for
open
it.
the door.
Adequately addressed it.
With this individual or even brought up this topic to make sure we did not end up in this point and place.
Mhm.
Judge, we thought we adequately addressed it last week during this sidebar.
Ms. Kaplan, what are you asking for?
Seeking exclusion, Your Honor.
Damn.
As to exclusion, what is your argument?
Oh,
That
shit.
this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are.
Miffed.
I didn't ask for any exclusion the first time this happened, or really any remedy.
Fucking miffed.
But
It's
you
already
admonish the
real.
defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So,
As to your point of the state getting a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may,
Last word.
viewing Earhart, exclusion of the witness, court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
Which
Absent,
is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to
Voir dire the witness then.
speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that Crawford can be taken on this matter. briefly review what I need and make a ruling. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor.
Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
Okay, Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual.
Oh my God, what
within the context of a family
stupid
law case.
expert
In the
anyway.
course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary
Exclusion of this witness wouldn't do
source
shit.
that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple of weeks ago just to confirm what I supposed were facts. And I have known Kristen for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markel's motions. And she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendi Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendi Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendi as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And you sat this morning through Miss Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Miss Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Gentlemen, an examination for the purpose of the proffer.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your
No, I don't
preparations?
Think so.
No, Your Honor.
Please step
So,
down, Ms. Bailey.
he can't, under their rules, I'm reading them now, he can't exclude her.
Is Jackie taking a nap? Oh, she's like, oh.
Return in a few minutes.
Good morning. Good morning.
So here's a 2003 case, and it said the trial court erred because its inquiry was insufficient to meet the requirements of Atkinson. That's another case. When faced with the sequestration violation, the trial court must conduct an Atkinson inquiry to determine whether the violation of the rule was with knowledge or the consent of the defendants. Wait, sorry, hold on, my phone's give me bit. Hold on a second.
Oh, she gone. She was here and then she was gone. Here and then gone. I don't know where she went. I don't know what she's doing. She was in the middle of reading some case
Sorry.
law to us. Oh, hi.
I thought it was one more second. I gotta make sure your dad's
She
taking care of
gone.
business.
She gone. Yeah, look, here's the bottom line. Hi, love bug. You've got like some mascara under your eyes, pretty heavy. It's like you're really having a intense sleep. Yeah, the judge in this type of situation, exclusion is not going to happen. But what judges like to do when lawyers screw up is make the lawyers sweat as much as humanly possible. So, he's going to go back. It's going to take some time. He wants Zellman's sphincter tightening a little bit. Like, oh my God, this absolutely non-critical witness isn't going to get the test. I mean, but so that's part of the game, is that judges will give the impression that they're going to do something extreme. They'll yell at you and shake their finger, and then they won't do it. So I imagine that's exactly what's going to happen here. He took a few minutes. He's like, I got to go back. Got a snack bag back there. About to eat a chip or three. Make Zellman, sweat a little bit out there in the courtroom. Have Donna give him the stink eye the entirety of the time that I'm back in chambers. I'm going to come back. I'm going to be standing. I'm going to give a stern look. I'm going to say, sir, you're a damn fool. You're a damn fool. However, you're lucky. It's too extreme. I'm not going to do it. Because ultimately, at the end of the day, it was of no consequence. I mean, this woman just testified on the proffer. Didn't learn anything new from sitting in there. It was shit she had already read from the transcripts from the prior trial, that being Charlie. So we're not going to have a situation where anything's going to get excluded. But like Allie said, even if he were to exclude, this thing is going to be, at the end of the day, this would be harmless error. Like whatever this person would be testifying to is not of the nature where it's going to sway the jury one way or another. I'm predicting. I think that train has left the station. I think there's, short of Donna getting on the stand and just blowing people's minds.
All right, sorry about that.
Fait complete. Where'd you go, puppy?
Your dad has the doctor switched it to a televisit, so he's supposed to get his text. I want to make sure it worked. He didn't get it yet, so we'll see. They said 10. So,
wow.
All right. So to determine the rule, or the inquiry to determine whether the violation of the rule was with knowledge, connivance, or consent of the defendant. So here, it's the violation wasn't with knowledge or connivance, like they were conniving, because the defense is admitting openly, I misunderstood him to be allowed to. So that goes against what the purpose of the rule. So it says where the violation was with knowledge or consent, the testimony must be excluded. Now, I don't think the judge should consider this to be with knowledge and consent, but technically I guess he could. You know what I mean? Obviously, the rule is saying like with knowledge that they're not supposed to be there, with knowledge that they're supposed to be sequestered. And this, because of defense counsel's misunderstanding of what transpired, I don't think it was with knowledge and consent, but it's definitely something the judge could say, you know. So this case goes on to say here the record reveals that the violation of sequestration was not with knowledge, connivance, or consent. The trial court did not inquire of the owner. I don't know what this case was about, so sorry. Whether the counsel suggested that he listen to the testimony. And then it goes on to say a second test. The Supreme Court restated the Dumas holding and further explained that the test to determine whether to exclude a witness is whether the sequestration violation changed the witness's testimony from what it would have been had the rule not been violated. Application of this test to this instance also demonstrates the trial court erred in excluding the testimony. The trial court's inquiry as to what testimony the owner the witness would give, but did not inquire as to whether that testimony changed the result of his testimony. Further, there was no evidence nor a trial court finding that the testimony actually differed from what would have been had he not heard the other testimony. The state argues for affirmance on the grounds that the error was harmless, but we do not conclude the error is harmless beyond a reasonable doubt. So I think for those
here, I mean, they had the advantage of there was a prior trial where the testimony came out during Charlie's, and I don't know if you heard that part of her proffer. She got on the stand and said, I had reviewed the transcripts from Charlie's trial, and the judge flat out asked her, he's like, did you learn anything new from sitting in during this testimony? And she's like, no. So
let me check and see how things are going with your dad.
Okay. So yeah, I think it's a non-starter. However, I think the judge is still going to make him sweat a little bit. But we got some blooping, so let's get up to speed. Bloop, 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 bloop. I think we're sliding action here. Sliding. All right. Let's see what Judge Everett has to say.
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give the state's benefit specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand. Are there any additional matters that need to be clarified? This needs to occur so we don't have any more issues with witnesses or other problems.
Yeah, Joe, it's a valid question you ask, but as officers of the court, yeah, judges are typically going to give lawyers deference in terms of being sworn officers of the court. So as opposed to, or in comparison to an average citizen, yeah. I mean, we are sworn to uphold the law, so it's a big deal. I mean, you get disbarred if you're getting up on the stand and lying. So yeah, there's
Everyone can be seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Thank you, Your Honor.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adelson, so
Okay.
we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law. And what that requires is an application that's about 3/4 of an inch thick that details all of your trial practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, et cetera. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay. And before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, Bailey.
Thank you. How many board certified family law attorneys are there in the state of Florida?
I
4.
believe there are about 274 according to the Florida Bar.
And do you know what percentage of lawyers in Florida are board certified in marital and family law?
I think less
17.
than 1%.
Oh, damn.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to
And they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
and judges also get that same peer review.
They do.
Do you have any other certifications?
I'm a board Supreme Court certified mediator. And that was probably the mid 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday. And then after the course, you do co-mediations with other mediators. And then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education. It might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years.
Truth.
Not sure how many.
Brutal.
They've also recognized my law firm as best law firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review. And the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests. Like, have you provided presentations? Have you taught? Have you done certain community service or pro bono work, that sort of thing?
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines. But at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to ordain the witness as to their training or experience. In objection to her ability to provide an opinion in the fields of marital family law.
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendi Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendi Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendi Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendi Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother. but most of their communication, I think, was by email. And I reviewed the emails that I was provided between Wendi Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendi Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendi, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendi Adelson in that process file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going. And it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendi Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel. Which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary. But then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage. So you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendi Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing.
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now we're using the term time sharing. We also have during the trial heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
Okay. And so the term custody is not something that is used in family law proceedings any longer.
Not between parents. The term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendi Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markel from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So in other words, when Wendi initiated the dissolution against Mr. Markel, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markel's motion to dismiss the petition for relocation. And then he had filed a motion to enforce life as he would have liked to have seen it. And then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce.
So,
and then,
in other words, he was asking the court to enforce something that they had agreed on, but hadn't been a court order?
well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by a court or even put into any sort of formal document. So that was denied.
So he would, let me understand correctly.
Expert
he
spediddle.
was asking for
Oh, you're back.
court
Pause it a
authorization to be able to go over to Wendy's house.
So we got another expert. Instead of making a splash, they're making a spittle.
Spediddle.
Spediddle.
Pediddle.
Wait,
Spediddle. Pediddle. Pediddle.
I know, but it's
Spediddle.
really spittle, right?
Yeah. Yeah.
Holy
spediddle.
shit!
Okay, you ready?
No, wait a minute.
Oh,
Wait a minute. People need it broken up anyway. I'm sure it's boring the fuck out of people. Although I heard
boring
none
the
of it so
fuck
far.
out of everybody.
Why
I'm-
in the hell are you calling an expert to say that their divorce wasn't contentious? Why are you doing that? How does that prove that all those emails where Donna is desperate to get her kids there, and all the testimony we've heard thus far, which is, I mean, something pretty severe must happen to make that. I mean, we're talking
severe.
very serious change in circumstance. Very. Like, how does an expert in divorce, I mean, I almost thought that's what the divorce lawyer testified to, right? Wasn't she an expert?
Well, they didn't tender her as an expert.
All right, so everything wasn't contentious. Seriously? This is what you're wasting your time on. I'd be like, if I'm a jury, I'd be like, well, where's your handwriting expert to say that she didn't write that shit? Like, why are you telling me that they're divorced? I could give a fuck less if their divorce was or was not contentious. I saw how contentious Donna was. I mean, am I crazy?
No, you're not crazy, but it was an email. I don't know how much a handwriting expert would help with that.
No, I mean the handwriting expert to deal with the letter to the, the
Oh, the
whole,
script?
yeah.
Yeah, the script.
Put an expert on. How about one that matters? I mean, they put their one on to say there were much less phone calls, and even though she said he wasn't outside of the house, there's no evidence she was there other than she said it. And now they put on, you know, it's just, but no, this one is worse than I think the last one personally. At least the last one had some points like, they would have went to hearing before the first two proposed dates, even though my understanding is this all started in October.
Doug, I think the expert, this gal here, went to law school with Wendy's attorney.
That's what I thought.
Not
she
Wendi.
said. Right.
Could be wrong.
Could be both, that she knows this other lawyer super well and also went to law school with Wendi, but
They seem a little bit longer in the tooth than
yeah,
Wendi. but,
age,
you know,
a little bit of an age difference there.
a little bit of a gap. The gap. Yeah, no, I agree. I don't know what they think this is doing, but again,
Right.
you're sitting down, you're trying to figure out what to do. in
Gotta
terms
put
of
somebody on.
defense.
Gotta
Donna's
put
like,
on
"You have to put
worthless.
somebody on." Yeah.
I mean, I just think putting on experts to just make a little is worse than putting on an expert at all.
Yeah.
I don't know.
I
Especially in this vein. You just had the divorce lawyer tell the jury, everything's normal here, nothing to see.
look, in terms of kind of a typical divorce, I think that everyone would agree this was a typical. It wasn't any more contentious than any other divorce.
No.
And you
no.
have a meddlesome mother who's, writing
Right.
her daughter emails.
Dude, this is
I think an argument could be made if Wendi gets charged. To me, these two lawyers support the proposition more if they are given the emails between Donna and Wendi. And then they ask, okay, well, when you got input from Wendi in terms of the pleadings,
did it say
did
this
she
shit?
give you any kind of indication to edit them to include such and such, which would have been mirroring what Donna had asked her to do? Meaning, like, Wendi was just completely ignoring, like, whatever Donna was
Right, but
writing. Wendi
at
didn't
the
give
end
a
of the
fuck.
day, babe, does it really matter if it made it to its lawyer? I mean, the point is Donna was saying it in hopes it was getting to the lawyer. I mean, that's
Well,
all that really matters.
Well, no, my point is if the case is brought against Wendi and I'm
Oh,
trying to
yeah.
represent Wendi and I'm saying, okay, look, Donna was saying all this shit to Wendi. Wendi was fucking ignoring her.
Right.
And like, if you're trying to push the blame back onto Donna, you could say, my mother maybe assumed that I was forwarding this shit onto my lawyer. I wasn't.
Right.
Maybe that could be construed as Wendi not doing that ultimately ended up pushing Donna to the point where she says, yeah, I'll fund this hitman thing because all the shit I'm trying to do ain't working.
Isn't working. Right. No, I
don't know.
definitely agree that these experts show Wendy's total indifference almost. I don't know about this one, but her lawyer making it seem like she just let me do whatever. She wasn't very involved. She wasn't pushing for shit. I mean, that-
Wendi seemed pretty agreeable to a lot of
Yeah.
it. I mean, like, which again, I get how everybody is like, when is Wendi getting divorced or when is Wendi getting arrested? I just like in terms of it's not about what we think, and what logic dictates in terms of whether or not Wendi had knowledge and was part of the conspiracy. You have to be able to prove it. Court's not about feelings. Court is about evidence. And like we talked about yesterday, does Georgia take a run at her? Maybe. Like now that if she gets this conviction, which I very, very much believe, I think that ultimately Georgia's going to leave it probably up to Ruth in terms of, because like Georgia's not going to feel like, all right, if I take the run at Wendi and I lose, Ruth's not going to be like, oh my God, you fucked us. She'll be like, all right, well, you took the run at her. It was a tougher case in terms of the evidence that you have to get somebody, because I think there exists enough. Let me put it this way. There is a lot more out there with regard to short of, and again, we have no idea other than what we've seen in this trial, what Wendi's responses, if any, were to her mother. Okay. Like they're like Georgia has all the emails. Georgia has seen everything. Georgia knows way more than we know about what kind of communications exist from Wendi. Right. But
Right.
if she's of the mindset, okay, look, I'm going to take the run at her. This is what we have. If I'm Wendi's defense attorney, there's a lot more that exists that we've seen that they could put forth in terms of a defense for Wendi than Donna had. I'll tell you that.
Right.
Because like you said, like when I read those emails from Donna to Wendi, it really shined a very bright light on just how meddlesome Donna really was. And like I think to me, Wendi was kind of like, based on what happened and based on what these lawyers are saying in terms of how the litigation went down, Wendi wasn't fighting Dan all that hard. Like, I mean, they ultimately agreed on nearly everything. She made the run at trying to get the relocation done. She lost it. She ended up stipulating to it being with prejudice that she couldn't bring it again. She doesn't tell her mother because she doesn't want to hear her mom's shit. And I don't know. It's interesting though. But like, I'm not so convinced. And it's not that I'm convinced that Wendi didn't have knowledge or wasn't a part of it. What I'm not convinced of is that they have enough to charge her. Like those are two completely different things. Like you have cases that exist in the world where cops are like, I know that son of a bitch did it. We just don't have the evidence to get him.
Right.
And
And
I mean,
because
this
of
could be
this,
one of those cases.
right. And because of this sequestration violation, the prosecution has tons of fodder on this to be like, well, you sat here and heard her lawyers say it wasn't contentious. It was normal. And you just said you're friends with her, you've known her, you respect her. So you're not going to get up here and like completely contradict everything that Wendi's divorce lawyer just testified to. But on the flip side of that, the defense will have, but you said this before that happened. You didn't change anything. Like this was your opinion before that. But she does have more information about how much this woman knows and respects Wendi's lawyer either way, whether she was sitting in the courtroom or not, to sort of undermine her. Although I just don't know.
Yeah,
You
I
know,
mean, I'm going to be, Miss Wildside, let the jury decide. I mean, that's certainly look in a typical situation. Okay, prosecutors, aside from Georgia, and because this case has spanned so much time, there's been so many trials, and they've gotten so many convictions. It takes it into a different realm in terms of your typical prosecutor. Prosecutors are not in the business of losing. They typically abhor taking anything to trial that they don't think that they can get a conviction on, or that they're not sure. Like
and I
every
think
prosecutor wants to feel like, you know what, we've got enough here to get a conviction. But again, Georgia knows more than we know. Okay. And everything is going to be tendered in discovery to whoever, if they do charge Wendi, whoever Wendi ends up hiring as her defense counsel, they're going to get everything. Okay. So, I mean, at the end of the day, we have to trust in Georgia. If she has enough, if Georgia believes that she has enough, even if it's a fence, if it's like on the fence and she goes to Ruth and she says, look, like I am in no way, shape, or form guaranteeing you as much as I can, which lawyers aren't allowed to do, but I feel very, very confident that we're going to get a conviction on this. And she tells Ruth, I'm not as confident against Wendi as I was against Charlie.
Ruth's
And
going to say,
Donna.
roll the dice.
Ruth's going to say, fuck it.
And I just
make the
have to
run.
say, I think there is enough here to convict, for a jury to convict Wendi. Although if I was on the jury, and obviously guys all know we're defense attorneys. So like my reasonable doubt level is freaking high, but we've seen juries convict. And for example, you know, Richard Allen, for example, Karen Reed, when they couldn't agree on the first trial, you had people ready to convict. You know, I think with her giving the schedule, although I have not heard to date, although I didn't follow the other ones closely, but not this trial, the prosecution confront Wendi with, why did you send the you know, the schedule? Because she could have been told by her parents, hey, we're thinking about coming to visit this weekend, can you see if you can get him early? You know what I mean? Like,
Yeah.
that could have been why that she did it, and that could be an answer, we don't know yet. But I do think there's enough inferences here with what we heard, and with the driving by, and with the giving the schedule. You
Yeah, I mean,
know,
the shit with Jeff Lacasse is unsettling. You know, the
mhm.
fact that she, you know, because Jeff brought out some pretty powerful shit, that she's taking all the kids' hand-drawn pictures off the wall 5 days before
Right, she's
it happens,
canceling
that
her.
she's canceling the cable
Right.
before the thing goes down. I mean, she certainly appears to be making moves, but you know, is Wendi a criminal mastermind? If she thinks she is, those kind of things that she's doing would tend to make me think she's the exact opposite of that. I mean, these are clearly things that, you know, she's taking the pictures down in front of Jeff. She's
Right.
canceling the cable, which can easily be,
Right.
you know, determined by the state.
She's
Okay,
suggesting to the
she's
cops,
driving by the fucking crime scene, like
right.
after, like those
She's
things.
suggesting to the cops, if anyone did it, my family was mad enough to do it. And
Right. I
Kylie,
mean,
yes, you are right. They are being strategic about what they asked Wendi, because she had immunity. Plus, you never want to answer. They would have asked her that question. I am certain she would have had an answer to it. You know, about why'd you give the the dates. Just we haven't heard it yet. So I do think there's enough there, and they'll probably make a go run at her after this. You know, once you get the mom and the brother, I
I
mean,
mean, the X factor in the whole thing is, if Ruth is like of the mindset, okay, I I think in my heart of hearts, Wendi knew. I don't think Wendi had a hand in planning it per se. I don't think that she necessarily knew that the wheels were really in motion. And she's like, and I've got my grandchildren who I have to consider their lives. Do I want to put them in a position, now that we've gotten their uncle and their grandmother convicted and in prison? Do I want now to have their mother, after their father's been killed? Do I also want to have their mother? I mean, in terms of the kids, I don't know.
yeah.
It's like everything's not as clear. It's easy to
But if
sit
you're
here
the
behind a
mom,
fucking screen and scream and yell, you know, it's, but like when you have to think about the impact on the people involved, you know, I don't know. To me, it's not as clear cut. It's just not.
right?
I
But
think you have to think about other
if you're
circumstances
Ruth
such
and
as this.
you blame Wendi, there's nothing that you'd stop at to say that she's not raising the kids of the father that she murdered. Like,
I mean, for
even,
sure. I mean,
you
that's
know,
the counter to it. But I mean, Ruth's been dealing with this for an awful long time, you know, and Ruth
Brian just stay
is,
alive. I think she didn't make it.
yeah, I don't know. I
And
don't
we
know.
could
We'll
crank
see.
her up to 1.25.
Who? Why, there's no rush. I mean,
Okay.
there's gonna be a
Another
2-hour
break.
lunch break or some shit. So,
Yeah.
you know, I mean, jump over to fucking Court TV if you want to watch this boring shit.
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just changed their mind. So he was trying to enforce conversations that he had had with Wendi that had no court order basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it. And he was basically saying that the petition for relocation was baseless and that the court should deny it. And the court said, no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendi essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the
She didn't
June
need to
21st,
appeal
2013 hearing,
because they were taking care of it.
did Wendi Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendi waived alimony. They adjudicated child support. They put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching
Visitation
rules
schedule.
on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator.
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in household. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances, plus best interest. Kristen talked about that earlier. And you have to, it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in if somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get him?
Oh, Susan.
Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson-Markel case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No, they resolved everything. Temporary parenting, permanent parenting, support, property.
How many months elapsed between when the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
It's very short.
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial.
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
No, to the contrary, it was settled amicably and everybody was moving on with their lives.
And quickly?
Yes.
during the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adelson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendi about the money he had not paid. But prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah. So, for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally, if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days. And then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So oftentimes, not oftentimes, sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company,
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140 something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendi Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool where the children went. And essentially, I did review that
Hey,
deposition,
glory be.
and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, were, I believe, Wendi, was she deposed?
I don't recall seeing that Wendi or Mr. Markel were deposed.
Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adelson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers.
Nothing unusual
Worried
about
about their
suggesting they
babies, not
change
all they are.
religions. Nothing
Now,
unusual
in
there.
the emails that you reviewed, did you see my client's use of the nickname Gibbers to just to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses,
That's not what I meant here.
It was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson,
She's an expert on
made
who's
at first
verbose
glance
and
seem somewhat intimidating,
worthy
but
of the
when we broke them
nickname
down
Gibbers.
paragraph by paragraph.
Come on.
They were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that that said the same thing. So he was a lot of
Babe,
his
you back there?
the things that he
If
filed,
so, pause
papers
it.
that he filed, which were signed by
Pause
his
it a
lawyer, but they
sec.
were consistent throughout all the lawyers.
So Bob looked up gibbers when it came up, and that's what like the online answer is, like someone who speaks gibberish, or something to that effect. Wendi said her friend came up with that name to like make him less of a boogeyman, like so to make him less scary. It was just a joke. Um the prosecution has been trying to make it sound like it's like some sort of derogatory derogatory word. There's nothing about that, but I'm just surprised the prosecution's not even,
Something came up and somebody put it like, is Jew in boots. Like I saw I don't like I couldn't find anything that was real.
nah.
I
That's
mean, Allie's Jewish, so I'm
he's
gonna go
she's
ahead and
I'll
take her
tell you,
word
this
for it.
family's not making up a nickname that's a slur on being a Jew.
Yeah,
No.
like typically Jews aren't slurring other Jews.
A
It's
Jew in
like not
boots? I don't think so, Farty Marty. But if you've got some actual more information about that, no, I believe it was just like, I mean, I've got no reason to believe anything other than I don't think it's Jew in boots. No. Uh-uh.
Hey, all right, so check your text real
Yeah, I said
quick.
all right.
Oh, okay. So, but what I'm saying is maybe you want to
Take over the feed. I should actually just do it right now.
Yeah.
What are we on?
She's making that
Law and
face
crime?
right there.
What
Yeah,
is it?
long crime. And it's their time is 11:27 a.m. Their
Okay.
thing. Like if you look where it says the actual time, like not on the slider, like above their logo.
Above their logo.
Yeah, see where it says law and crime, then it's got the time.
Oh, yeah.
Yeah.
And you said it's
So
what time?
11:27 a.m.
Oh,
EDT.
all right. That's nice. That's helpful.
I'll be back. I've got a Zoom meeting. Optimistic. It's with a production company about two things. Gacy being one of them. The other one about potentially getting a docuseries done on our podcast, Gacy podcast, which is long
Oh.
overdue.
Oh, I haven't opened it in YouTube. Jesus. Hold on.
The one thing I feel confident about is that I'm not going to miss Donna's testimony. Like if that's happening, they've basically got lunch to shit or get off the pot with her. She's got to make a decision. And remember, it is strictly Donna's decision. I mean, her lawyers can advise her. And I mean, if you're her lawyer, babe,
Yeah.
and it's a lot of times, whether or not your client / defendant is going to testify, we will say, hey, all right, here's the deal. Let's play it by ear. Let's see how their case goes. If we feel like we can get away with not having to put you on, that's preferable. Yeah, they did make a Devil in Disguise miniseries.
Dude, I think I nailed it with that face.
Close. She looks a little more evil right there. She's got she looks like the dark Sith from she's got like just put that hood on her. Yeah, they did make a mini series, and I happened to see that they have Gacy sitting at counsel table with one lawyer. So I was pretty fucking pissed about that. Like it's already on my shit list. They're pretending like my dad wasn't in the case.
Is the lawyer short? He looks like Sam.
He doesn't look anything like Sam. He might be short, but I don't. It's
maybe
not
his
my dad.
name
He
is
didn't
like
have a mustache.
Robert
None of them.
Amaranti.
Wow. Just wow.
All right, bye, babe.
All right.
Oh, you're not leaving yet.
y'all.
You're not leaving yet. I'm just taking over.
No, yeah, I'm gonna get ready. So
all right. Well,
all right.
Glory B needs something from you real quick.
Aw, family hug.
There you go.
Oh, and Pamela, thank you for your $25 Venmo. And she said, thanks for pausing.
You're on the wheel.
You were on the wheel. The wheel's slowly building up for the huge, massive, fat sticker package. So, all right, I'll be back.
All right, here we go.
Somewhat intimidating, but when you broke the
I'll just go back.
if you look somewhat applicable, he was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings.
Expert
because
opinion.
They just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was.
I've decided that the prosecution's not objecting because they want to convey, like, I could give a shit less what this person is saying. It doesn't matter because, I mean, yeah. I mean, you're all saying the same thing about this testimony, but, All right, let's go.
Complaining about fraud by Wendi Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them. And he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew the Schwab account existed. That was easy.
I cranked it to 1.5. So if a lot of people complain it's too fast, I'll crank it back down to 1.25.
And so you can't say fraud. I made a decision without knowing. And then in the next paragraph said, but I knew these accounts existed. That's why I know she's committing fraud.
Thanks, Shannon.
So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendi filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said, her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client in the emails you review appear to push back on Wendi and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think it was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendi responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw
And then
between them.
certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they are very involved, I'll ask to meet with them and bring them in, because what I don't want are third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day because other facts might come in, other considerations might come in. Because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn and they understand how you reach an agreement. And then the litigant, the party doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue.
I can't even tell this is
at. I'll definitely ask to say,
1.5. It's so
your boss,
slow.
your brother, your mother, so we can kind of talk through this because I need them to understand my position and maybe theirs will change.
Now, you were provided with a number of emails that Wendi was sent by her mother. Did you see evidence that Wendi shared those with Kristen Adelson?
I saw no evidence that Wendi shared them.
And did you speak with Ms. Adelson about that?
Yes.
Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adelson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendi Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time, child support, the division of childcare, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, childcare, insurance, health insurance, and parental time.
Exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets because he said he earned more and he created the assets more than she did.
It's tomorrow.
Which is not a valid legal position. And
Oh,
she
it was
got
Thursday.
to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that by agreement.
And you mentioned keeping the boys kosher. Was Wendi Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendi Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendi Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say, you need to go to your therapist and follow their advice.
Was Wendi Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements because kids don't want to see the parents fight every birthday.
Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement?
No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that
I
is
straight up thought it was Thursday
decisions that are
today.
healthy for the kids.
Wow.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendi a lump sum and Kristen Adelson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendi Adelson and $10,000 towards attorney's fees to Kristen Adelson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendi Adelson?
Yeah, yes.
Now, later,
But it's very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those and they got a very typical marital settlement agreement.
so from September of 2012 until the final judgment in July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months
True.
later,
I was just going to
the
highlight that
payments for
too.
Mr. Markel were due in 60 days. So that would have been due at the end of September. And so, taking Kristen Adelson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish plus the 10 for fees.
So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did. And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendi to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendi was going to be staying in Tallahassee?
Yes.
I mean, I'm surprised
It's
they're not
done.
objecting.
When you say it was done, what do you mean?
I mean, Wendi waived her right to appeal that by agreeing that the relocation be dismissed. So
Now, prior
With
to final
prejudice.
judgment being entered,
That's a significant.
would Wendi have been able to attempt negotiating with Mr. Markel to try to get relocation, even though the judge denied it?
she could have.
Would there be anything improper with Wendi or her family through Wendi offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who did to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want or to get less time. So depending on your financial circumstances, that number can be wide ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation. So that's routine.
Nothing
Routine.
unusual about that.
Routine.
Now, you testified earlier that you were provided text messages between Wendi Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it was a few months period, even after these motions had been filed that kind of upped the temperature a little bit. And they were working well. I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see.
Not the
They were
day
very
of
flexible
the
with each other.
homicide. They were bickering
Now, you
over.
indicated earlier that
hours.
October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so that she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief did include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it would be helpful to see the pleading itself.
Sure.
May I approach the witness?
Approach with courts 1 states demonstrative A, specifically page 338.
Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
And the body of the motion, does it seek anything concerning contempt?
in the body, which does not control the ask of the court, which is called a wherefore clause. And under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendi is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line. But then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same. Order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here. She's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
Come on.
In the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013
God,
had
she's
merit?
still on the stand.
And what were the possible repercussions to Mr. Markel?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markel emailed the parenting coordinator and Wendi Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendi in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendi to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kid said something like, "Grandma thinks you're stupid," or something like that.
Did Mr. Markel file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February. And I believe that was set in December. And it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you sent this document. And it went to Mr. Adelson's new lawyer in December.
Mr. Markel?
I'm sorry, Mr. Markel's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendi had these other financial violations. And then she referred to the Schwab account that you forgot, a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendi. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendi Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that.
There you go,
To know
Travis.
what the then value was, but those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then, according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that, and it wasn't legally supportable.
That's not a valid defense.
Pardon?
That's
Two
not a valid
wrongs
defense.
make a right.
Defense, no.
Two wrongs do make
Now,
a right.
if he
What do you mean?
If a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adelson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you didn't disclose, or that they had some stash of gold bars somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle.
Sure, and
overcome.
it had impacted you. In this instance, it was clear from Mr. Markel's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did a January 31st response, and then he did the motion against Wendi on
Whoops. Sorry, I was trying to move
financial
these.
issues, February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and the number of phone calls wasn't required. He was asking for, there was some right of first refusal. He didn't like that when his parents would come to town, that she would maybe go to dinner with friends and let them spend time with the kids, or she would let them stay home from school so her parents could spend time with them, and they were little babies. And he didn't like that because he wanted to be able to go to the childcare during her parenting time so he could see them every day. And I think the child care person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adelson filed a motion to dismiss about?
That may have been, I was thinking she filed it against February
Predictable.
14th, but
Cardi B won.
my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful.
I still want to watch all this Cardi B stuff.
So it looks like on April 11th. Nope, that's his response. Let's see. My recollection was correct. She filed a motion to dismiss on March 10th, to dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
motion?
Correct. And then that was all set for hearing for May 15th.
I think she's off the stand.
The complaints that he raised in the March 26, 2014 motion, you indicated.
Oh, you're really looking into the future,
that
babe.
He was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like.
But it's not what it looked like.
Required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made well into this very long motion was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that, I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show a material and substantial change in circumstances, and that it was in the best interest, and there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that, because he's talking about what purportedly a 4-year-old may have said to him. And I think even in this motion, he says, I don't know if this is true or not. I don't know if Wendi was present or not, but I would like Wendi to make it stop if it's true.
Did this motion, the March 26, 2014 motion, that the state has called the grandmother motion, Did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe 0.45, and then he kind of tied in this grandparent thing on 0.8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school. So he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendi to have to call him so he could watch the kids even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if my rule, or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. That's a normal part of a kid's upbringing. And so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town.
For a certain period of time.
Okay.
Why
Now,
aren't you-
have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar to what Ms. Adelson described the judge saying in the middle of the relocation hearing, which is don't file things like this. I don't think it would have been well taken by the judge at all because it was a complete waste of everyone's time and money and emotion because it was baseless. It didn't tie to anything.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his violence?
No.
Why?
You have to do a supplemental petition if you want to.
Bloop.
Does it appear to be intimidating?
No, I think when I was making notes, I put insert by role here. It was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendi Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have, and that's one of the reasons I wanted to call Kristen because, again, when I read that motion, I was kind of taken aback that a lawyer would sign that and allow that to be filed. And I thought it was kind of nonsense. And I wanted to get Kristen's take on that and see if she agreed. And she did. And she said that she had advised Wendi that. And that's what I would have expected from her.
In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendi had sent her mom a couple of documents. I know the petition for relocation that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions because, like since that relocation is extremely difficult and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition. But after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Oh, because she's about to be done.
Would Mr. Markel have been able to sustain his burden of proof for that motion?
I'm sorry, say that again?
Would Mr. Markel have been able to sustain his burden of proof for that motion?
No.
No, I don't think so at all. If you're talking specifically about like 0.8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay. And I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just, there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
A hotly contested case or a high conflict case, how many pages are in the court file?
I think there's roughly 570. They'll do a motion, they'll do a memorandum that says the same thing, then you may do a response that says the same thing, or in different order. So 570 though.
Do you know how much in attorney's fees Wendi Adelson incurred, attorney's fees and costs for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adamson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
Can I show the witness the demonstrative?
Wow. He's going to bring over her whole file for this other case. Be like, is this that case? How much?
2, Volume 4.
Wow.
You recognize this file?
This
Yeah,
is
I
the
think I
stupidest thing I've ever
This is
seen.
fucking stupid. What are we doing? Oh, look at the binders. So many binders.
A example of a hotly contested relocation case.
Well, I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000.
I mean, I
so it
don't-
doesn't appear to be all of it.
Pause it for 1 sec.
And there were 2 volumes on the record on appeal, so perhaps only one
Oops,
of those
hold on.
volumes got
Sorry.
So the
Wow, this is the stupidest thing I've ever seen.
It's fucking stupid. And I saw a couple comments. I don't consider them talking about, because remember, I mean, the state's theory in this case absolutely revolves around these proceedings and the relocation. So I don't consider them kind of diving into what happened in these hearings to be victim shaming Dan.
No.
And I don't consider them pointing out the fact that it was contentious between the both parties to be contentious or to be victim shaming Dan either. I mean, divorce proceedings are shitty. People say and do shitty things. I mean, that's no reflection on the person's character per se, you know. So I think it's fair to bring this shit up. I just think that it's of no consequence. Like, that's at the end of the day, I don't think that they're moving the needle at all by pointing out what the fuck was going on in the underlying proceedings, because it's not helping Donna. Like I said, this may be helpful if they decide to charge Wendi, you know, to bring this shit up and then be
Right,
like,
but
"Oh,
what they're doing right now, literally, oh, you had a contentious divorce that involved relocation, and they're just bringing over the binders, like, boom, look at how much paper is involved in a contentious one, and there's only 500, and there's one binder in the Markel divorce, and look at all these binders. I mean, it's so stupid.
so stupid."
Ugh.
People like demonstrative evidence, though, you know.
All right, there we
Babe,
go.
so
What?
Annie was telling me to go, the loophole lawyer called me gay, babe.
Who's the
sad for
loophole lawyer?
Or some dude with the channel. Because when I was telling Alessi and
So
Yannetti, I
what?
had man crushes. I know.
Nothing wrong with being gay, although you're married.
I was just telling you, just
Yeah.
let you know.
Bob wouldn't mind.
I'm like,
if
I
he-
don't
if
give
he
a
was,
shit if he
He'd be a
called me
proud
gay.
gay. He'd
What
be a
I-
proud
what
gay
I-
if he was gay.
Yeah, what I was offended is he kept calling me this guy, like he didn't go to our channel and pull our fucking clips, and he's pretending like he doesn't know who I am. That was kind of douchey.
I mean, I say let's not even talk about him. It wasn't worth the breath. You just.
I mean, I don't think he was necessarily being critical, but it was like,
Oh.
like this guy, like he doesn't know who the fuck I am. Come on, bro.
I mean, come on. All
Kind
right.
of whack, a little bit whack. All right, I digress.
The clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Well,
Yes,
it's more
based
than
on
that.
Just assuming 500 pages for no vote.
Wow.
Can you tell the jury what the issues were in that case?
Oh my gosh.
Judge, may we approach?
Wait, he's bringing more binders.
Judge, we're entitled to make a record. I believe I
He said
After the
no.
jury, the bailiff will take you to the jury room.
Unless
What?
He's making a record. He's making a record because they wouldn't let him ask some question
In this
about
case,
what
it's
was.
certainly relevant. You may be seated.
Here you go. Wait,
The
let me.
relocation issues with
Hold on. Let me just slow it down.
in this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this
I'll go on one
proceeding is the witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees
No.
that were incurred and the expenses that were incurred,
Nah.
so that we can make the comparison to the case that involved Wendi Adelson and Mr. Dan Markel.
Nah.
Gentlemen, any other argument on this issue?
It's relevant, Your Honor.
As to the point on relevance, the court's ruling remains the same as to issues of relevance. Again, the relocation that is disputed within this case as it relates to the divorce file certainly is an issue. As to any other case files, this witness may testify concerning or experience, but we're not going to go through this case file in its entirety.
Oh,
Please bring back in.
or how much
Your
she.
Honor, that was not
Thank
my intent
God.
to go through the case file in its entirety.
Blooping.
All right.
Judge, we plan on
Please
going
step
through
down
it
so
pleading
that
by
the
pleading.
courtroom doors. If you can radio Deputy Bunk to leave the jurors in the room, please approach. Thank you. And I'm going to remind you, do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. Jurors using the restroom. Please use the restroom or stretch your legs if you need to. We will continue with the witness.
All right. And we're back.
Whose phone? Is that your phone?
Yep.
No, Mav. No. Cardi B, the plaintiff's counsel on that guy takes the cake.
Takes the cake. Takes the cake.
Big time cake taker.
Yeah.
Taking all the cakes.
Was
Like, has Jackie just like checked out? Like, she hasn't done anything during the defense's case in chief. Has she called a
Yes,
witness?
she has.
What?
I don't know.
I don't think she has.
No,
Maybe one witness.
I
She's
can't
doing a lot
remember.
of sitting. He's doing all the arguments. He's taking all the beatings. And Jackie's just kind of chilling.
All right, let's go.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic.
Gibberish.
You know, he used a lot of inflammatory language. But when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
Asked to do in this case.
I was asked to
Why?
review the documents I was given and to opine about whether this was truly a highly
Babe, do you have the
contentious
sound boost
case,
up?
essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide.
Wow, that was not an appropriate question. I don't know what this super boost is that you speak of. So,
No, just the 2 times. I was just wondering.
oh
if you,
yeah.
Like,
Yeah.
I mean, I've got extra boosters up top. Like, I don't know if it helped or not, but I put it on. I can hear it fine, but like, we're backstage, so I don't know. Can you guys hear it well? Like, I hear the witness very well, but the lawyers not quite as much. Or maybe it's the opposite.
I can try another volume boost.
No, just stick with the 2 times the YouTube booster is the best one.
That's
Sure.
the one. All right.
I mean, I've done 2,000 cases or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that?
No,
Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case as a lawyer might be routine, whereas to the parties it's the most important thing in the world?
To some degree, that's one reason I called Kristen, is Ms. Adelson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had something similar to what Mr. Markel would file, the immediate response is to call your client, go, I know you're going to read this at first glance, so it's going to seem messy, but there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendi.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What
Oh,
is
come on.
no big deal to us is a big deal to these litigants, right?
Not when they
You can't
agree to
with
it.
that. You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered?
Georgians.
Yeah, where's the judge like, I'm gonna need you to not make any facial expressions or gestures that tell the jury that you think what the person just said is total bullshit.
Right. Which, I mean, I'm enjoying it, but
Right,
I mean,
I'm
what's
enjoying
good
it
for
as
the
well.
goose is good for the gander.
Right,
Is like, that was, she's like, this fucking bitch. Like,
right.
really?
Yeah, come on.
Because that was a
mean,
pretty good analogy. It was a pretty
very good analogy.
with the
Very good
garbage
analogy.
bag. I
She
enjoyed
should have
it.
just answered, but however they agreed in this case, that's why I'm saying it's if she said it once, she should have said
Well,
it again.
and they're both attorneys. Even if they don't practice divorce law, they're they know what the effective pleadings are, and they know,
Right.
it's like there was some legal jousting going on between both of them, and they were being snarky in the pleadings. So I don't. She gone. Bye. Take care now.
All right, let's go.
Side based on. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law
I've
litigation?
never had anyone murdered. I had in one instance, a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
Derived.
that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset.
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma.
Exactly.
It shouldn't have
No,
been. There
no
was
comments
proof,
by the counsel.
It shouldn't have been, in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
She got her there.
Mhm.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that
Oh, see, so
definition or by your definition of someone that speaks gibberish.
all right. Well, then I take it back from the. I don't know where that came from. It's not what Donna said, but
I don't know. I saw this Jew in boots. Like somebody posted like a picture of it. It was like the cat in boots type
right.
thing. Or the cat. I don't know where it came from.
Well, clearly it came from something. She's saying that's evidence in this case. So I apologize to everyone who said that, but it's not
Yeah,
what Donna said. I mean, not Donna, Wendy. So I don't get
know
it.
what it is. I don't know.
Well, we'll need to research further out, although I might not care enough.
It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Ms. Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right?
Well,
Right?
But we can't ask Dan.
Yeah, I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It's just a matter of jumping through hoops to get the money.
He was either going to pay or he was going to get sanctioned by the court or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you?
I
And Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Pause
Ultimately.
it. Pause it.
Wouldn't even
real
come
quick.
into play until the motion for enforcement and then
Just so you guys have an understanding, if you file what they call a rule to show cause, which is what they're referencing right here, and you see it a lot in particular in child support cases, or if there's a court order that is telling one of the parties to do something, a lot of times it's pay money, whether it be through the marital settlement agreement, whether there was a judgment was made and there's a house that's getting sold, and the money, if it's not in the hands of the lawyers, which typically you have no problem getting the money from out of the trust account of one of the lawyers to the other lawyer's trust account, and then they cut it. But if it's one of the parties that has to cut a check, and you go into court and you say, all right, well, look, there's a court order and this person's violating it. So then they'll have a hearing to find out whether or not it was a willful violation of the court order. And then typically what happens, like Allie and I have done plenty of these, the judge will say, okay, look, there's a court order. You're supposed to pay, in this case, 80 grand. You're not doing it. You seem to be willfully not doing it. Here's what I'm going to do. I'm going to find you in contempt. However, I'm going to stay it. I'm going to set the purge amount, meaning if you pay the 80 grand, this goes away, but they'll create a purge amount, which typically either is all of the
But-
money owed or a large amount of the money owed. And
They-
then sometimes they'll even sentence them to jail. So they'll say, I'm going to sentence you 20 days in jail. However, I'm going to stay that and I'm going to set a purge wherein if you pay it before this week, and I'll give you 7 days to purge it. If you make the payment, then you're not going to go to jail. So, I mean, they can put you in jail. Like,
But
frankly,
just-
child support is the one area where there actually is debtor's prison.
right. So that's what they said when, I don't know if you were on here, that this didn't involve child support. So there was no risk of him being jailed, and they didn't ask for him to be jailed in the pleadings. They were just trying to enforce the judgment. So with
Well-
property, they treat it different than child support. That's what this, the lawyer before and this witness testified to.
Wait, he's saying that she said, because it sounds like it was coming from the retirement funds, right?
Sale of the marital home. He was supposed to pay her.
I don't
portion.
even know why Dan had the money. It should have been in his lawyer's trust account, like upon the sale. Typically, it
Or
typically is.
I think he was keeping it. He was buying her out.
Whatever the case may be. Like,
Right.
I don't, in Illinois,
So
are
not
you
the
saying
sale,
that if
right.
it's not related to child support, that the judge, if you're in violation and it's a monetary thing, I don't know that it has to be child support. If you owe
But
money out of,
I'm saying what these lawyers said about in Florida anyway.
all right, bloop it back because I didn't hear that.
I-
I heard something else. I thought she just testified that the other lawyer said. Maybe I misheard it.
possibility he was going to end up in jail.
Sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And Ms. Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
Wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms. Adamson was incorrect on that point, I guess.
Objection, Your Honor, that question that we strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on that witness's testimony.
Please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendi. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever. And then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation.
Timed out
technically,
Travis?
If you wanted to go to jail rather than pay Kristen the $10,000,
Jesus.
eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 to Wendi. It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendi taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see him.
And did you see in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendi then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Ms. Adelson, Ms. Donna Adelson, about relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October, maybe.
Okay.
Several months.
October, right around the request for the hitman.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right?
Yes.
I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Oh boy.
Obviously.
That's the end of that. Should be
Nothing further.
Oh, but there's more. Oh,
Markel's pleadings.
oops, sorry.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law. And I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud. And it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make
Upsetting.
the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay. So if somebody had been murdered in that case, there might have been a lot less paper, right?
Yeah.
Case
Well-
would have been shorter if somebody gotten murdered, wouldn't it, Miss Bailey?
Yeah.
If
Come
there
on.
wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
We might.
no, because the divorce was over in July.
Well,
Divorce was over in July, but they kept filing papers, didn't they?
Well,
Yep.
and the case was set for hearing March 15th. I mean, excuse me, May 15th, 2014. So the motion that Ms. Adamson filed in October and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again. And on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw. So they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even after that was resolved, there was be nothing stopping them from having a bunch of other time sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Overruled.
No, yeah, you opened the door.
Yep.
Well,
You brought the binders up, Chief.
Piled them right
I
up.
guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th,
True story.
and had Wendy have been
It
successful,
is a true story.
he would have very likely had to pay Wendy's attorney's fees. And I really encourage
Generally
my clients in
prevents
these
them from doing it
situations to take
again.
it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But
So
that hadn't happened yet.
it had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly,
Because he was murdered.
clearly.
May I have a moment to confer, Judge?
Mhm.
Mm-hmm.
That's all. Oh,
Briefly, Your Honor.
please, briefly, please spare us all.
Ms. Bailey, you sat through Kristen Adamson's testimony earlier today,
I
correct?
did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
I think lunch is next.
At this point, we are already.
What are you doing?
He's
Enjoy your
he's
break.
breaking it for lunch. Report it
I know,
there.
but like you just blew
Okay.
by. Like,
2:15. Enjoy your break.
what time?
2:15.
20, please.
2:15?
Well, stop talking.
At 2:20, please report by 2:15.
Yes.
Enjoy your break.
2:20.
At that point, are there any other matters that we need to address?
Judge, I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court, cautioning the gallery again. I don't know what steps the court needs to take in order for that to stop, but the fact remains that they're doing this in front of the jury, could have an impact on the jury, and could impact on clients' right to a fair trial.
What are they doing?
Making
Well,
faces and
this
sounds.
is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed or you're able to identify them.
They're behind me, Your Honor. No, all I can identify is coming over my right shoulder.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you are engaged in a disruptive behavior that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. cannot make this any clearer at this point. Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Ms. Desclazo, I believe, is still to be called by the defense.
Yes, Your Honor. Mr. Scalzo and Ms. Newhouse are slated.
Concerning the rule of sequestration, the remaining witnesses understand they are not to be in the courtroom.
I'm not aware that they have been, Your Honor.
Please
But
stand in the
did you-
courtroom to make sure none of your witnesses are present, so we do not have any continuing violations of the rule of sequestration.
I don't see any witnesses in the courtroom, Your Honor.
And tell them.
Please return at 2:15.
All right.
Yeah, just say if you're a witness in this case upcoming,
Get out.
get out.
All right. I got some work to do on this lunch break, so you figure out what you're doing while I get the house
Oh.
ready for your family later.
Okay. Let's see. What do you guys want to do? We could listen to. I mean, we know there was a resolution in Cardi B's case. Do we think it's worth listening to closing arguments? I kind of want to. What do you guys think of that? I mean, Cardi's always like a very good palate cleanser in between what's going on in this case. Like Cardi, yeah, she was dozing. No Cardi. Bump says no Cardi. What, the closings were hideous? Closings were so boring. I want to hear the rest of her. No, they were horrible. Both sides were horrible. All right, I'm reading. Let's listen. Seems like it's 50-50 right now. Closings were awful. Plaintiff closing goes down in history as see, to me, that's worth watching. Like the worst closing in the history of jurisprudence. I mean, I don't know. I think Allie really just wants to watch, like, she likes to watch Cardi. Like, she doesn't give a shit about the closings so much, I don't think. Do more court. So let me see. How much should I, like, I don't know that we had much left. I think I was through probably, I don't know. Cardi B testimony in civil court. Let's see, I needed, it was a couple hours. Let's see, so no, that's a shorty. That's a shorty too. This might be the one. Let me see. I can't remember where we were at. Let's see. Oh no, see that ain't it. Oh yeah, see this is like a mashup kind of here. Oh. Oh. Yeah, I mean, the judge didn't kind of put it to Zellman about whether or not Donna's made a decision whether or not to testify. I don't know. All right, yeah. Court TV didn't bleep it out. Yeah, I definitely like it not bleeped. Definitely like it not bleeped. No bleeping. I kind of want to watch the plaintiff's closing argument. The guy's just so shitty. So shitty. Doctor testifies. Let's see, Cardi B's testimony. Let's see. Like, I want to see the unadulterated, full-blown. Cardi had a lot of hairstyles going in this trial. Like, she had different hair every day. It's pretty impressive. All right, let me see what they got for the playlist here. 32 videos. Okay. Yeah, see, a lot of these are shorties. Incident. She's so cute. Love Cardi B. All right, let's see. Let me see. Oh, yeah. See, this is only 1:40. Why the hell are they making it so hard to find just the testimony? We need the day. We need day 2 of her testimony. That's where we left off. This is 49 minutes. So I don't know. I don't know. How far were we into that? Let's see. I'm going to pull this up. I saw Auntie Deb use this clip yesterday. It's pretty cute. Let's see. Okay. All right, so we go full screen.
If my arms were disabled? No, my arms weren't disabled. No.
Can you raise your arms up?
Objection, Your Honor.
Can you? You don't have to do it physically. I'm saying, are you able to do it?
Yes.
And on that day, you were able to do it as well, correct?
If I wanted to, yes.
Okay. That's all I'm asking. Aside from your disability of being 3 to 4 months pregnant, did you have any other disabilities?
No.
Do you have a disabled placard? Are you legally disabled in any way?
Why don't you move on, Counsel?
Yeah, it wasn't there.
And the hoodie that you had on, what color was it? Was it black, white, yellow, purple, pink?
I really don't remember.
And was the hoodie over your head or
Yes.
no? You wore it for what reason over your head? To protect your identity?
It could be I don't really want people to recognize me. My hair not done. My makeup not done. I probably just woke up. A lot of reasons.
And when you went there in the afternoon at 1:30 p.m., had you just woken up at that moment? Well, shortly before 1:30 p.m. on a Saturday?
Objection, relevance. Sustained.
When you went to the building at 1:30 p.m., were you fasting or you had eaten something before you went to see the doctor?
Sustained.
Now, when you saw Miss Imani Ellison and you got out of the elevator, not asking who did what, I'm asking was there any contact between you and her of any kind? What that means is fingers to fingers, shoes to shoes, knees to knees, any contact between you and Imani Ellison of any kind. Was there? Yes or no?
No.
So she didn't touch you, correct?
No.
So if somebody comes here and testifies that she did do something to you physically, you disagree with that testimony, or you will, correct?
She didn't touch me.
Okay.
She didn't get to touch me. No. She was going to touch me, but she didn't get to touch
When you
me.
say she was going to touch you, how do you know that? You
Because
assuming?
we were chest to chest at one point.
So then your chest did touch, right?
I'll say that, but you did say when I got off the elevator.
Okay.
Yeah, who's attacking Cardi B's appearance? She's gorgeous. I don't know what the fuck y'all talking about, man. She purty.
We
Let's-
we walked a little bit. That's when we got chest to chest. When we got off the elevator, we didn't do no contact.
I understand. So here's how we're gonna do this. The date of the incident is February 24th of 2018. You agree?
Yes.
Now I'm gonna talk to you about the whole day. Not just the minute you got off the elevator. When I say the whole day, from the moment you got off the elevator, you saw Imani Ellis, you had your fight with her, whether it was verbal or not. At some point, she went away and you went away.
Mm-hmm.
So during that segment of time of your life, which was how many minutes in your opinion? 5 minutes, 2 minutes, 1 minute?
It was probably like a minute 45. It was so quick.
Perfect.
It was really quick.
Perfect. So from during the 1 minute and 45 seconds.
No. I didn't say 1 minute
You
45
know, we
seconds.
haven't had a question yet. Please phrase one that's intelligible.
During the few minutes or 1 minute or whatever minutes it was that you were with Imani Ellis, during that period of time of your life and her life, during that segment, just told us now, during that time period, at some point, you were chest to chest. You agree?
Yes.
There was physical contact between her chest and your chest, correct?
Yes.
Now, when you have the chest-to-chest contact, at that moment, were you angry?
I was mostly nervous.
Were you angry?
Yes, I was angry.
How angry were you?
Depends on the level of angry, to
Right.
be honest with you.
Let's talk about the levels. I'm going to go from a scale of 1 to 10. On the scale of 1 to 10, what was the level of your anger when you were chest to chest with this person?
Objection.
On the date of the incident.
Sorry. Objection taken ambiguous.
You were at a high level of anger when you were chest to chest with her, correct?
Objection recommended. Overruled.
I don't think I was like on a high level of angry. I was more on a high level of concern, very concerned.
And why were you concerned?
Because I'm pregnant and this girl's about to fucking beat my ass. Hello?
Hello. Hello, I'm here. So when she was going to beat you, like you just testified, what did she do to have you believe that she was going to beat you? What did she do?
She was on my face, chest to chest, and while we arguing, she's backing me. So we're practically arguing, and I'm backing, and she's like walking forward.
Right. And she's, you said she's bigger than you, is that correct?
Absolutely.
How do you know that?
I mean, look.
I'm looking, I don't agree with that. What is your basis? Are you saying she's physically bigger, she's taller?
I mean, you have her medical records,
I don't
right?
have anything. I want to ask you the question.
I mean, I was 130 pounds at that time.
So she's overweight, right? In your opinion?
Objection relevant.
She's a little.
You don't need to answer me.
Okay. Did you make fun of her that she was overweight when you were there in the hallway?
I don't think so.
Did you call her fat?
No, I was calling her a bitch.
Bitch?
Yes.
You think that's respectful to call a security guard a bitch?
Objection. Sustained. Relevant.
Is that how you talk to everybody?
Objection. Sustained.
Now you
Being
said
a
you
bitch.
felt. I don't know the words. Let's go back to it. Did you feel scared, threatened, afraid at the moment your chest was touching?
Absolutely.
You were scared?
Absolutely.
And you had your cell phone on you, right?
I did, but she's in my face.
That's fine.
Just focus on the question and just answer.
Did you use your cell phone to call Karan Newton, your security guard, who was downstairs, or the police?
Objection.
Did you call anybody for help?
Overruled.
When I got inside the doctor's office and I said like on the little bed thing, I told him, yo, you wouldn't even believe what just happened. Meet me downstairs when I leave. I'm gonna call you when I leave.
If you were really scared and really afraid, isn't it true that you could have called your security guards to come upstairs and help you. Or you could have called the police. That was a possibility because you had your phone in your hand, correct?
Objection. Compound mischaracterizes the testimony that the phone was in your hand.
Assisting.
You had your phone in your pocket on the date of the incident?
Objection relevance.
Assisting.
Can we agree that you didn't call your security guard to help you after the incident, correct? To help you. You did call him, but you didn't call him to come upstairs.
I apologize. I thought you said mischaracterizes the testimony.
Overruled.
You know.
I didn't call him to help me. It was already done. It was done.
Okay, now let's talk about the fingernails. Okay, fingernails.
Something new?
Well, I want to show a couple of things about the fingernails. So this side of the ruler, okay, is 2 centimeters. You need to bring it closer. Can you see it from there?
Objection, Your Honor. You went over this yesterday.
I'm sorry.
2 centimeters. You know the size of 2 centimeters? How big it is?
Ask an answer.
I have like an understanding of how it would be. Yeah.
2 centimeters. It's a little bit less than an inch. Okay? Now, Miss Imani Ellis had a scar to her face of 2 centimeters long, and she received plastic surgery for that.
What?
And my question to you is, did you at any time see a scar on Miss Imani Ellis's face or a cut?
What kind of fucking quack plastic surgeon said, yeah, you know, you need some plastic surgery on that scratch on your face? What? I mean, I Googled yesterday. I was trying to find this scratch. I don't know. I saw like a picture or two. I don't know. You're typically not getting a permanent scar from somebody scratching you with their fingernail. I mean, not that I'm aware of.
Or a scrape at any time during the time of the incident?
No. And she couldn't get a scratch from me because I didn't touch her.
I understand that's what you're saying. I get it.
Dermablading.
Did you look at Miss Imani Ellis's left cheek at any time during the incident? Did you specifically look for that because you thought there might be a scar on her face? Or did you not look?
Objection. Compound and relevance.
Assisting.
Did you look at Miss Imani Ellis's face when you were arguing with her at the time of the
She was
incident?
standing right in front of me, you fucking moron.
I was looking at her face, but I wasn't looking like, she got a pimple on her face? No, I wasn't looking at her details or anything.
So if she had a scar on her face or cut, you wouldn't be able to know because you weren't focusing on it, correct?
Objection calls for expert testimony. Relevance.
Assisting.
Stupid.
Counsel, she's a fact witness. She didn't see a scar. 121.
Is this guy for real?
You testified yesterday that when you go to get your nails done, you tell your nail person to be careful not to make your nails too sharp. Do you remember saying that?
Yes.
Do you tell them that every time you go to get your nails done?
Objection relevance.
Assisting.
Did you tell your nail person that before you had your nails done, just before this incident?
I didn't have to because of the shape. So the shape that I had that week, it wasn't like a shape that is like harming. It was like a square coffin shape. So it didn't have like no points or like sharp edges and stuff like that. I mean, there's pictures of me of that week everywhere. So
Do you have a picture now with you? Do your attorneys have it?
yes.
The nails that you have on now, are they sharp and pointy?
I don't consider them that. No.
You consider them pointy?
No.
Can those nails that you have on now, can they become sharp to the point where they could cut somebody if you were to scratch them?
Sustained.
Did you see any skin or any blood underneath your fingernail after the incident? Any of your fingernails?
There was no physical incident for me to even see nothing like that.
That's not what I'm asking. I'm saying if you saw anything.
No.
Okay. Did any of your fingernails break after the incident?
No.
All 10 of them were in perfect condition?
Yes.
When you went to see the doctor, Dr. Finke, did he look at your fingernails? Did he go over that with you?
No.
Did you even bring it up to him?
No, I just told him like, it's like, this is your security? This is your security?
Besides your chest to chest touching, did anything else touch?
No.
Okay, and you're a firstborn child?
To my mother, yes.
Okay, and you have other siblings, other brothers and sisters? Right?
Mm-hmm.
Is that a yes, ma'am? Is that a yes?
Yes. Sorry.
Okay, and as you testified yesterday that the baby in your stomach that was 4 months or 3 to 4 months old was your first child, correct?
Mm-hmm.
And you've had other children, correct?
After? Yes.
Beyond the relevance.
Sustained.
Okay. Now, back to the words. I asked you yesterday if you used the N-word, if you called Miss Imani Ellis the N-word. You said you did not, correct?
No, I didn't.
But you've said that word before in your lifetime, correct?
Objection, relevance.
Sustained.
And in your music, you actually say it many times, correct?
Objection,
Counsel,
relevance,
move on,
First
please.
Amendment.
Do you know what the word ghetto means?
Objection, Your Honor.
Sustained.
Relevance.
Did Miss Imani Ellis call you ghetto?
I don't remember.
If someone called you ghetto, would that make you angry?
Objection, relevance.
Overruled.
Me?
Yeah.
If somebody calls me ghetto, it depends on how you're using it, but I don't really feel offended if you call me ghetto.
Did Imani Ellis tell you that you're stupid?
Your Honor, relevance.
I
Overruled.
really don't remember. She did. She was cursing at me though.
What were the words that she used?
You're gonna get the fuck out of my building. You're gonna get the fuck out of my building. I can do whatever the fuck I want. Then it's like when I was telling her, like, it's like, why you recording me? She's like, it's my fucking phone. It's my phone. You're in my building. That's what she was telling me. And she was like, yeah. She also was saying, like, I don't give a fuck who you are. I don't give a fuck who you are.
Okay. And you remember her telling you that?
I remember that.
Those exact words?
Yes.
And did that make you angry?
Yes.
I mean, he's definitely trying to get her pissed. She's not going to get pissed. Like, I mean, there's no question he's trying to get her to say, yeah, I'd be like, he wants to be able to create a situation wherein she said something that would have triggered her to be angry, you know, with the ghetto thing, the bitch thing, you know, all the bullshit. So she just wasn't biting on any of it.
Absolutely.
Okay. When you get angry, you black out and maybe not realize what happens next.
Objection, Your Honor, relevance.
Do you know if you blacked out on the date of the incident? At any time?
I think
Oh my God.
All right. And when you were yelling back and forth, and you were speaking and yelling and screaming, you were, correct?
See?
You were yelling and screaming at each other,
Yes.
correct? When you were doing that, did your spit come out of your mouth and go onto Imani Ellis?
I don't think so. No.
But it's possible, right?
Objection.
Because when you're speaking, sometimes you use many, many words, the spit comes out, correct?
Objection.
You agree with this?
I'm sorry, what's the objection?
Well, relevance, Your Honor.
Over.
You can answer.
I'm not sure. I don't think so. I don't think it'd be happening. I don't know.
Could it be that Miss Imani Ellis was not recording you with her phone?
Objection.
Is that a possibility?
Objection called for speculation.
Sustained.
Aside from what you've just told us now about the recording, is there anything else that you have? Any other testimony about how you know Miss Imani Ellis was recording you with her phone?
She told me when I told her, why you recording me? She said, oh, my bad. She practically apologized.
Did she apologize to you?
If you say, oh, my bad, when I'm telling you why you're recording me, to me, that means you're recording me. And it's right there, right now. It's on my face.
Well,
Not on my face, literally on my face. I'm trying to be as detailed as possible, but she had it right here on her chest, like this.
and when Miss Imani Ellis told you to leave the building, you refused to leave, correct?
Correct.
And at that point, you were trespassing, correct?
Objection, Your Honor.
Sustained.
Where did you go? Did you leave the building? Did you go to your doctor's office? Where did you go next?
To my doctor's office.
And where did Miss Imani Ellis go?
I don't know.
Did she see you walk into the doctor's office?
Objection called for speculation.
Sustained.
Did you see Miss Imani Ellis when you walked into your doctor's office?
Did I saw her?
Right.
Who was arguing? The receptionist came out. She got in between us. They were like, kind of like, she was like trying to calm her down. The doctor was already coming out. And he was like, go to my office. So I'm like, after that, I just went to his office and I never seen her again.
Okay. And when this, how long after, from the moment you saw Miss Imani Ellis, how long after did the doctor Finke come out of his office? Was it in the middle, towards the end?
I mean, Finke, the doctor, the OBGYN, testified whenever he had, and I don't know if it was a couple days ago, and he came on and he's got celebrity patients. Frankly, if he's hiring, and now I don't know if the building hired or if he hired in particular, but you got to make sure you're not hiring like star fuckers, people that get all worked up when they see somebody famous. Like, you can't have that type of person as your security guard, because this is the kind of shit that happens. Like, anybody who doesn't think that this woman was filming her is out of their fucking mind. Right? I mean, clearly she was filming her, obviously. I mean, we all know what it looks like when somebody's using their phone to film something these days, right? It doesn't take a rocket scientist to figure that out. But yeah, I mean, I see that people are saying the building, that makes more sense. Obviously, though, if you've got an office in that area and you're going to get celebrities in there, whoever is hiring from the building has to be cognizant of the fact that there's going to be people of note coming in there, and you can't hire people that can't control themselves.
You're still replaying what we saw yesterday.
And can you give us an estimate of time?
Can I go back and replay the today and Adelson?
Sure.
No, thanks.
So, just for argument's sake, I'm gonna estimate the time was 2 minutes. I'm not saying it was, it could have been half a minute, just for argument. So during the 2 minutes that you and her were outside in the hallway, screaming at each other, whatever you're doing, for those 2 minutes, how long after the 2 minutes, or sorry, how long from the beginning of the 2 minutes to the end did Dr. Finke come in? So he could have came in at 59 seconds, 119 seconds, 1 second. Do you understand my question?
But it wasn't 2 minutes though.
Time out. Sorry, go ahead.
It wasn't.
I'll withdraw the question.
All right.
All right, let's do it again. How many seconds, I need to know this, how many seconds were you and Miss Imani Ellis in the hallway? Let's just pick a time. You pick.
I'll say from like the beginning all the way to like walking down, it had to be like a minute or less.
Okay. And you say walking down, you mean walking into Dr. Finke's office or leaving the building?
Excuse me?
When you say walking down where?
Remember, I got off the elevator, so I'm walking, trying to find the room, the office. So in between that was like the minute there. Like I like the verbal dispute, it had to be like 20 seconds of that.
Fine. When did Dr. Finke come out of his office?
At the end.
When it was all done, correct?
Mm-hmm. Well, when Tiara was calming down, she was still like screaming and like trying to explain herself to Tiara. I just walked away.
All right. When you got off the elevator, was there anyone else in that hallway or in that vicinity?
No.
And how long did it take before Tiara came out?
How long did it take?
And that's Tiara Malcolm.
Yes.
What's your best estimate?
Like 40 seconds at most, or like 50 seconds, like around there. I don't know.
So you and Miss Imani Ellis were alone for approximately 40 to 50 seconds before anybody came out into the hallway.
Yes.
Right? And in those 40 to 50 seconds, anything could have happened.
Objection.
Right?
Sustained.
You could have scratched her face. You could have cut her face in those 40 seconds.
Counsel, we're not going to engage in speculation. If you have fact questions, ask her. Or please do so.
When you had the fingernails on that day, what color were the fingernails? Do you remember?
They were like
Green?
No, they were like orangey.
And you said that there were some kind of flat, I don't know, stones on them?
Yes.
Were those flat stones on all 10 fingernails?
Most likely, yes.
Were the 10 fingernails all the same size and had the same exact stones on them?
Mm-hmm.
So if there was one stone,
Yes.
if there was one stone, it would be 1 stone times 10? Or is one might have 3 stones, another one may have 1 stone? Do the stones change?
Objection. Vague, ambiguous, culture speculation.
What do you call them? The things that you said yesterday, what did you call them that were on your fingernail?
Flat rhinestone.
Flat rhinestones. Were any of them sharp?
Not if they're flat, they're not sharp. If they're like 3D, like popping up, they sharp. But if they're flat, they're not sharp.
Okay. And do you ever wear the ones that are 3D?
Objection, relevance.
Were you wearing the ones that were 3D on the date of the incident?
No.
At any time?
No.
And how do you know that those rhinestones that are 3D, how do you know they're sharp? Why did you just tell us that?
Counsel, why are we talking about things that she didn't testify she was wearing?
Do you remember how many rhinestones were on each fingernail? If it was 1, 2, or 3?
Objection, that's the answer.
Sustained.
Aside from that day, the date of the incident, which was February 24th of 2018, aside from that day, have you ever seen Miss Imani Ellis either before or after that day?
No. Honest truth, I wouldn't even recognize. Like I totally forgot how she looked until I came here again. Like.
Well, isn't everything you just told us the honest truth?
Yes.
Now, when Miss Tiara Malcolm came outside, she came outside, it was about 40 to 50 seconds, and she came out first, right?
Mm-hmm.
How long after that?
Yes.
How long after that piece did the doctor come out? Because he came out after her, right? They didn't come out together, did they?
Tiara?
I withdraw. Piece of time. Right. Anyway, when Tiara Malcolm came outside, did she come by herself or with the doctor or someone else?
She came out by herself.
So how long after she came out did the doctor come out?
He came out like 4 to 5 seconds later, 3 seconds later.
When Tiara Malcolm came outside, how did she get between the two of you if you were chest to chest?
She literally, she was like, "What are you guys doing? What's going on? And what's going on?" And then she was like, "This bitch just fucking hit me. This bitch just hit me. I'm about to fuck her up." And I'm just like, I'm so confused because it's like, no, I didn't. Like, I didn't hit you. And then that's when like Finky came out, and he's like, what's going on? Go to my office. So I just like went to his office and stuff like that. Like, that's it.
Right, but you testified that Tiara Malcolm at some point was in between the two of you.
Yes.
You got a hamburger bun with a hamburger.
Yeah.
She was a hamburger, and the two of you were the buns, correct?
Yeah.
Right. How did the hamburger get inside the bun?
I'm not sure if I gave her space or one of us gave her space. She wasn't like really like in. She was just like, "What are you guys doing? What is this?" And then she just got in the middle because she just was like going crazy. I don't know where she just turned up like.
And you just testified now that Imani Ellis was yelling that you hit her,
Mhm.
right?
Yes.
She was saying it,
Mm-hmm.
and you didn't hit her.
No.
Did you take a swing at her?
No.
When Miss Tiara Woods was in between the two of you, did you try to take a swing over Miss Tiara Woods?
No.
How tall are you?
I don't know who Tiara Woods is, but.
Tiara Malcolm, I apologize. Tiara Malcolm. How tall are you? How tall are you?
How tall I am?
Yeah.
5'3".
Okay, how about on that day of the incident when you had your shoes on? Were they flats? Were they heels? What was it?
Slightly flats.
So, and do you know how tall Miss Imani Ellis is?
No.
When you were standing face to face, were your eyes like the same level, or did she look taller? Did she look shorter? What is your recollection?
We was face to face, so she's practically like my height, or just a much taller, but she was practically my height. But she is like
What? Say it.
security heavy.
What does security heavy mean? Just tell us. No harm. What does that mean?
Like she just looks a little like she could protect a building type big. You know what I'm saying? She just
Right.
looked more developed than me.
And aren't security guards to be more developed than you?
Assistant.
Did you at any time tell Miss Imani Ellis that you were pregnant?
No.
That building, you agree, is not Cedars-Sinai Hospital, correct?
Objection by submission. Also, this was covered.
I withdraw the vote. The building you were in was a medical building, correct?
Yes.
But it wasn't a hospital.
No.
Was it a hospital?
No.
And there's all type of different tenants that are in the building, right?
Objection by submission.
Do you know if there were other tenants that had offices in that building?
Objection.
You were on the 5th floor, correct?
Yes.
And when you were walking down the hall, there were other doors there, correct? It wasn't just Dr. Finke. There was other different offices there, correct?
Objection relevant.
Sustained.
When you were getting angry, did you believe that your anger would harm your baby?
Objection relevant.
Sustained.
When you went to see Dr. Finke, did you tell him, I got so angry right now, something happened, whatever you told it, is it harmful to my baby? Did you ask him?
Sustained. That's everything.
Earlier, well, I'll withdraw that. Did you post anything about the incident of February 24th, 2018 on the internet?
Objection relevant.
Overruled.
I think I said something because around that time she did went live and said something, and my fans caught it, and she was just practically saying like all of these lies about me and stuff like that. And I was like, I did not touch that girl at all. I never really got into details about it. I just.
And when she was posting things, she was telling other people that you assaulted her or hit her or did something physical, correct?
Yes.
And then you replied and posted things as well, correct?
Yes.
Do you remember what you posted?
I don't think I posted something. I'm not even sure if it was a comment or like if I did like a live or something. It had to be quick. I was like, that's a fucking lie. Look out of here, trying to get some money.
What was that?
I said, that's a fucking lie. Fuck out of here. Just trying to get some money.
Who's trying to get some money?
She is.
How do you know that?
Because she sued me for $24 million.
Did you sue her?
No.
Could you have sued her?
Objection, relevant.
Did you ever apologize on those internet or emails or whatever you posted? Did you ever on the posts apologize for anything that you did that day?
Objection, relevant.
Do you feel by using all those words you should have apologized?
Objection,
Are you aware that your security guard spoke to Imani Ellis in the lobby shortly after this incident? Are you aware of that?
Explanation.
I'm not aware of that. He didn't tell me he talked to her.
Are you aware that your security guard, Karan Newton, on the day of the incident, apologized to Miss Ellis on your behalf?
Objection.
Did your security guard tell you that he apologized to Miss Ellis on your behalf at any time?
Objection. Asking answered. Argumentative. Lack foundation.
Have you ever been assaulted and battered in your life?
Objection, Your Honor.
Have you ever been abused in your life?
Counsel, if you're out of questions, you can ask a question.
Did you know that by your actions, you took away the feeling of safety for Imani Ellis?
All right. Counsel?
Yes, sir.
Are you done?
I have a few more questions.
Have to be fact-based.
Yes, sir. And do you agree that this incident, which we're talking about, why we're all here today, occurred 7.5 years ago? Are you aware of that?
Yes.
Okay, that's 2,741 days ago, based on my math.
Relevant, Your Honor.
Sustained.
How do you remember all of these details that you gave us from 2,741 days ago?
Objection. That's 2 days.
Overruled.
You can answer.
I mean, I remember like the basics. I don't remember like the whole. I remember the basics. Like it was, but it's not really much to remember. It was a in and out thing.
All right, and have you ever used your nails to scratch yourself? Like if you get a bug bite, have you ever done that before?
Objection, Your Honor. Relevant.
Sustained.
Did you have any jewelry on you at the time of the incident, whether it was on your hands or your neck?
Objection. Ask the answer. Relevant.
Sustained.
When you were in the hallway, did you block Miss Ellis from leaving? Even if it was for 1 second?
No.
Did she block you from leaving?
Yes. She blocked me from moving. She was right in my face. She was right in my face.
Okay. And when you were standing there, were you facing Dr. Finke's office or a different side? You understand the question?
Objection. Negative.
I withdraw the question. When this whole thing happened, did you start to move around in a circle, or were you standing physically in the same spot the whole time?
Objection. Ask the answer. If you heard it.
Sustained.
When you say that she was blocking you, were you facing towards Dr. Finke's office? Yes?
Objection.
Sustained.
Yeah, we got a hot minute for Adelson starts up again. For more riveting testimony.
Karan Newton, how long was he your security guard as of the day of the incident? For how long?
Sustained.
Would you consider yourself a peaceful person?
Objection to all.
Sustained.
And after you saw Dr. Finke, you spent about 15 minutes with him, you left the building, correct?
Yes.
When you left the building, did you see Imani Ellis as you were exiting?
No.
Did you see your security guard downstairs?
Yes.
He was in the lobby area waiting for you?
That's the answer.
Sustained.
And when you left the building, you went to the parking lot, or was the car waiting for you outside?
Objection to all.
Sustained.
Objection. Asked and answered. Relevant. Sustained. Sustained. Sustained.
Hey,
Sustained. Sustained.
look
Ah,
what it
man, a
is.
master class in sucking.
You were popping in. Like
Yeah.
I thought you were out doing shit.
I did my shit.
Allison.
Allison. Yeah, no, I was just about to get into, I talked about this a bit the other day. Look, I mean, there's plaintiffs' lawyers out there that, like any profession, there's good, there's bad, there's average. But in terms of kind of like bottom feeder plaintiffs' lawyers who just will sue anybody.
And so
Yeah,
this
they're
is
out
just
there.
an opinion right here.
Yeah, this is just an opinion. But I mean, this case, he looked at it, this guy's looking at it like, all right, I'm not going to have to put up much money, because the way that most civil cases work is that the plaintiff's attorney, which is the person doing the suing,
And who has to put up all the money on a contingency case?
huh?
And who
I'm
has to
going-
put up all the money on a contingency case?
Right. So, I mean, typically on a contingency case, you're not getting paid until and unless the thing either settles or you go to trial and you win a judgment. And then you get your fees. So you have to front the cost typically. I mean, not in all situations. Like Allison and I have had situations like, we'll handle it, but you're going to have to front the costs for X, Y, and Z.
Yeah,
Like
if it's a
we're
really
like,
bad case and somebody's insisting on going against our advice, we'll say, look, we'll take maybe a lesser percentage at the end, but you've got to front all the costs.
right.
We have to
And
hire an
that's usually
expert.
for somebody that we're like friendly with, like doing it kind of as a favor. Like it's not a great case, or it's like a family friend or some shit like that. But case like this, you've got megastar, huge money. This woman walks into his office. He gets all excited. It's like, Cardi B. Oh shit. Cardi B. He's like, oh, that fucking scratch is horrific. Oh, we're gonna, so like in his mind, he's got little downside on the front
I
end.
just pictured the Kramer's lawyer
Yeah,
in
yeah,
Seinfeld.
yeah. That guy. It's outrageous, preposterous. This
It's
is
outrageous,
Jackie
egregious,
Childs.
preposterous.
Jackie Childs. So in this situation, you've got, like I said, a high money defendant, the potential for some kind of recovery. You've got, at least from what he knows, some kind of injury wherein she's claiming she went and, had to have some kind of plastic surgery or cosmetic surgery in order to fix this scratch. So he's like, oh, there's some shit there. I'm not going to have to spend a fortune on, any kind of experts. I can use the treating doctor as a witness, and I'll take a shot at it. It's like my outlay is nothing, little to no risk for me. The problem for him is that this thing was televised for the world to see. Now, I mean, while he may have no financial impact in terms of he's not out of pocket in that he lost, but now he's been out there for the world to see in terms of what type of trial lawyer he is, which I think is not good for him. And
Upset, I think.
now that she has won the case, party can turn around and seek attorney's fees from them. And they can come after the lawyer for the money as well. Like there was a frivolous pleading. So, I mean, now there is a downside. Now there is a bit of a downside. So, you know, like the impact on his career, I don't know. I mean, he sure looked like a tool to me, but you know, what do I know?
That's an opinion piece.
He has good review. You can trust reviews, lawyer reviews, about as far as you could throw them. Like they're bullshit. Like half the time it's family members. You know, it's like, and you're always going to have like the one truth about being an attorney is that you are always going to have unhappy clients.
So if there's no bad reviews, they're bullshit.
Yeah, if there's no bad reviews, then you know it's bullshit, because anytime you lose in court, especially like family lawyers, like you are going to have pissed off clients that are like, "Oh, my lawyer sucked. We got hammered," because you lost, you know, but it's just par for the course.
I think that's the worst pause of Cardi B yet. And she paused on Cardi B yet, and she still looks adorable.
She still looks lovely.
Aside from Tiara Malcolm and Dr. Finke and Imani Ellis, who were in that hallway, were there any other people there?
No.
Did any other doctors come up to that floor?
No.
You're sure?
Absolutely.
How are you sure?
I mean, stupidity.
When you were in the 5th floor, did anybody come from the stairwell up to hear what happened? If you know, do you know if anyone did?
I apologize. I thought you were done.
I'll withdraw it. I will ask it differently. When you were up there outside the hallway with Imani Ellis, did you see anyone else, whether it was a security guard, another doctor, or someone else, come up from the stairwell, which was close to the elevator area?
Objection, that's the answer.
Sustained.
Buddy, it's just getting worse.
I forgot to ask you one thing about when you were chest to chest. Did you ever touch Imani Ellis's face or nose with your finger?
No.
You never touch her nose like this?
No.
Oh, babe, you picked it. Why
Thank
is
you,
it live?
All right, we're going to take our morning recess and we start back up at 10:50.
That's the whole thing.
No, I mean, like, why didn't you just play that full day's testimony? All right, so I don't know how
couldn't
long
find it, to be honest,
closings
yeah.
are, but
No, we let's see here. Hold on. We'll do this. We're going to go to her presser, little presser afterwards. It's short and sweet.
wait, before closings? All right, yeah, let's see what she said.
People said the closings sucked, but
Yeah.
man. Okay. See what she has to say here.
Thank the respectful press. I really, really appreciate that. And I want to thank everybody at home supporting me. I know you guys having a little key with the moment, but to be honest with you, I have missed my kids' first day of school today. I missed my kids' last week of school yesterday because of this. And I'm not even playing around. I would, even if I'm in my deathbed, I swear to God, I will say it in my deathbed. I did not touch that woman. I did not touch that girl. I didn't lay my hands on that girl. And with that being said, this time around, I'm going to be nice. The next person to try to do a frivolous lawsuit against me, I'm going to countersue. And I'm going to make you pay. Because this is not okay. I think people have like this misinterpretations of celebrities. Like it's like, oh, well, we can ask for this and they're going to settle. You don't work at home and you don't work all day and you don't work for your money to give out your money. So don't ever think that I'm just going to give you my money that I work hard for. I don't lay in bed all day. I work all day. And I work hard for my money, for my kids, and for people I take care of. So don't you ever think that you're going to sue me and I'm just going to settle and just give me my money. It's not going to happen.
Tell them, Cardi.
I do also want fans at home, though, not to find their social media, her family's social media, her social media, and bother her. I hope that this is something that I leave behind, that she leave behind. Don't go bother her. Don't be talking about her. Don't be talking about how she looks. Don't call her no nasty names. Let's just put this behind, but I'm giving a warning. I am not that celeb that you're gonna sue and you think it's gonna settle. I'm not gonna settle,
Yep.
especially when I'm super completely innocent. I know I got a little reputation, but I swear to God, I'm innocent. I swear to God.
We believe you, Cardi.
Like I'm really innocent for real.
We
And I just
stand
want to
with you.
say thank
We
you,
stand with you.
everybody. It's been really tough. It's been really long nights for me. I'm in the middle of album rollout, so it's been late nights
Am I the drama?
and early 5:30 in the morning. Yeah, I gotta get up 5:30 so I can look like this for y'all. Muchas gracias para toda mi gente latina que me están soportando y vinieron toda la mañana. Ustedes se ven bien maquillada, pelo, cuerpo bonito y vinieron para acá para
5 días.
show me support. 5 días. Y los hombres también.
Una peluca diferente.
Una peluca diferente. I'm telling you guys, when I say that my forehead is raw from changing all these wigs, raw. And yeah, thank you for the witnesses and thank you for everybody that just took their time to come out. No.
They came back so quickly with this verdict.
No, pero solo un warning para que no
It says that it's bullshit.
De que cualquier persona que te vuelva a hacer algo así, que demandar, vas a contrademandar.
Voy a contrademandar, tú a ver. Si me joden otra vez, lo voy a contrademandar.
Good camera work.
Yeah.
This guy's trying to get an angle.
It's really funny that people are just like, oh, she's amazing.
Oh, sorry.
I'm just saying
Didn't mean
the
to
truth.
bump your
I'm
head
just
there,
telling
buddy.
Everything as much as detailed as I can remember. I'm just telling the truth. To be honest with you, like I didn't do nothing special.
Tus abogados hicieron un gran trabajo.
Sí.
Tus abogados hicieron un gran trabajo. ¿Cuál crees tú que fue la estrategia perfecta de ellos para contigo y ganar este caso?
Diciendo la verdad, siempre diciendo la verdad.
It's all the truth.
Tú sabes, el tiempo, las horas, investigando, tiene que investigar.
Por eso tú decidiste irte a un tribunal, ¿verdad? Porque
Sí.
sabías que era...
Ay, ¿tú piensas que es fácil darle a una gente tu dinero?
No,
Yo estoy trabajando. Una mierda. Ay, es fácil. Yo pensé que yo tenía que...
Oye, Carlos, tus hijos, ¿cómo están?
They're good. I got two birthdays.
Cardi, what did this case take out of you? What did this case take out of you, Cardi?
Un saludo al gol de la placa. You guys are amazing.
Cardi, you plan on celebrating your birthday?
All right.
And like I said, thank you guys for the 7 years.
I thought there was somebody said some shit that she threw a
This
marker.
or my album.
Did.
Oye, Carmen, ¿cómo hacer algo con Yaelina más real? Sí, pronto.
Having that album, having this done, being able to move on.
It's a lot, but I'm ready to move forward. And please stop asking me about people you don't see. Let you know this right now.
She's out. Let her go.
Give us some space. Give us some space, guys, please. Thank you.
All right, back up.
Give us some space, guys. Give us some space. Thank you.
Carly,
Watch your backs. Watch your
I
backs.
hate that stuff. Weak.
Jaws. Push them a little bit
All
forward.
right, guys, at the back up, please. Back up. Back up.
Thank you very much.
Back up, please.
Cardi, we love you.
Back up.
Done with it. Done with it.
Back up, Carly. Back up.
Back up, guys. Back up, back up, back up.
Mis hijos quieren una foto contigo, por favor. ¿Dónde quedan? Donatio. Ven. Donatio.
I'll take it for her.
Allá están mis hijos, pero ya no los van a dejar.
How you like the court TV coverage,
Y
Cardi?
vinieron para ver. They got good angles of me. They had good angles.
Court TV angles was amazing. Can I get that on tape? Pop in.
What TV? You had some good angles of me now.
Court TV?
Oh, somebody's opening
Except
up
for
the
the
door.
Except for the first day.
I had you covered though.
Except for the first day.
I had you covered though.
Yes, you did. Thank you.
You're so beautiful.
Thank you. Let me go. I'm hot.
Take care, Cardi.
Thank you.
Start backing up, Lavani.
Coming out, guys. Thank you.
Oh,
I mean, what were you watching her pull away?
yes, that was it.
Well, we still got 30 minutes.
Phew. What are you gonna do?
I don't know.
what are you going to do? I think you're going to have to kill time. Take care.
No,
Have fun. Just kidding.
I'll just let people put a little "we'll be back soon" thing and let people hang.
Yeah, we could do this. We could put the cord up. The great sign. I wouldn't mind like trying to snarf some snarfing.
Yeah, some snarfing.
Snarf some snarfles. Snarfling. Snarftastic. Snarf. The dog's good. Dog's good. I mean, I thought it was from that little presser. Like, where else would she have thrown a marker?
Why would
I
she
don't
throw a
know.
marker?
I don't know. No, I don't like. I mean, his theory of defense was crazy, but I thought Rashbaum was way better than these two lawyers, in my personal opinion. I mean, that guy tried to sell it the whole way.
Yeah, this says 8 hours ago.
What?
But it's the New York Post, so.
What says 8 hours ago?
Cardi B throws a marker.
It was probably some douchebag from the Post.
That was a New York Post.
No, I mean, it was probably, she probably threw a marker at somebody from the New York Post because they're
All right.
such bottom feeders.
I'm watching it.
Okay.
Oh, she threw a marker. All right,
Did she hit a dude right in the face?
Yeah, he deserved it. Hold on. I got
Okay,
you.
it's the next trial.
Here we go.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time. Do you foresee any paternity issues with Stefan Diggs?
Stop. Cardi, how you feeling?
It's too bad she missed.
I mean, come out of your trial that somebody talked shit and you didn't throw anything, fists or anything, and throw in a marker.
Yeah, and miss. Like, who'd she grab it? She grabbed it from somebody. She tries to
grabbed it from the podium.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time. Do you foresee any paternity issues with Stefan Diggs?
Oh no, yes, somebody gave it to her. Just to autograph them.
Cardi, how you feeling?
I love that. I love it.
Oh God.
Yeah, like the paparazzi are so much. They're just the way they swarm. It's so weird. It's like, it's like the race to be able to sell your shit to TMZ to make bank, man. It's like, I don't know. People just love shit with celebrities.
All right, so I don't know if you answered this, Holly Johnson's question.
Will you please explain the benefits of sitting on the exercise ball? I think I'm thinking about getting one for my other half. Love watching you bounce.
So they make a little like seat that goes on top of your seat, and it's just like, for your core, for your balance.
No, there's a back. There's no seat that on top.
Well, no.
of the ball.
They sell just like a seat cover that's like kind of like a half a ball,
Yeah,
like the bottom's flat. And that's so that the person's using their core to sit. We just got these, and this is like the chair. And it's basically for the same thing, just like, just because it gives you the option. Like I lift up my legs and I tighten my core, but yes, it's for
I'm
the
always
core.
working the core on this thing all day. Like I used to get pretty bad backaches sitting, like if we would be doing a trial, sitting on a chair. Like the middle of my back would be killing me by the end of the day.
Yeah.
But once I started sitting on the ball chair, which I rarely lean back because there is like a little low back rest. Yeah, it works your core. It's good. If you're sitting all day and you don't have a stand-up desk, I think the ball chair is a pretty good way to go. And
I want a stand desk though. All right,
I do
Scorpion
too.
asks, I don't think allowing all this divorce stuff was appropriate, but I don't know where the line should have been. Prosecution brought it in. They should be allowed to defend it. I mean, that's right. The prosecution is the one who made so much a big deal out of the divorce proceedings.
It's motive.
Yeah.
They don't have to prove motive, obviously, but it is the motive as to why this happened. It was born directly out of this case. So I mean, the defense is going to have the ability to be able to challenge it and to bring it up. I mean, the effect of it, I mean, Georgia was obviously very effective in her cross of the expert
Yeah.
with
Yeah.
respect. And I don't know why that expert wasn't just being more forthcoming.
Yeah.
Of course, people are upset when you are handling a family law / divorce / parental allocation type proceeding. It is highly emotionally charged. You're dealing with people typically at their lowest point emotionally. If you've got a marriage that's failed for whatever reason, if they're going through a fight over who's going to have their children for, what period of time, that's, of course, emotionally charged stuff. And for that lawyer to act like oblivious to that fact was weird to me. Yeah, you can say that I've seen worse. I've definitely seen litigation that was highly, like way more highly charged than this was. That they've done crazy shit. They've said crazy shit. They're, putting air tags in each other's cars. They're, stalking, like all kinds of shit. All that kind of stuff goes on. So in terms of the pleadings and, harsh words that are said about one another in the pleadings doesn't diminish the fact that for each individual out there that, yeah, they're feeling things. It's an emotional thing. I don't know that there's anything in terms of court of law that's, not criminal in nature that's more emotionally charged than divorce cases in custody. I mean, if you have a situation wherein you are accustomed to spending every day with your kids, you see them every day when you come home from work, and then that's ending. I mean, that makes you feel certain ways. It's like it's not a great feeling. So it was weird that she was kind of dying on that hill, which gave Georgia the opportunity to really. The garbage analogy was great. It just was. It was very effective.
Yeah.
And it's
So
like it was unnecessary to try to diminish the fact she can say like this was kind of more of a par for the course type proceedings. There was some snark, some shitty things filed. In my opinion, Dan's motions that he filed late were frivolous. Law didn't support it, and I'm sure she was right.
yeah.
If there was no backing in the law, then they were frivolous, and Dan probably knew that.
Right. He's a lawyer.
Which from the perspective of one lawyer looking at the fact that they have a lawyer party is going to be like, all right, well, he knows better than this. He's just filing it to be, mean or just to harass or whatever the case may be. I mean,
Right.
those are honest evaluations from an attorney looking at the case and just saying, look, these were frivolous. They were never going to win. So, you can take from that what you will in terms of whether or not they were done to simply harass because, counsel would have known that they really had no shot in prevailing on those. And like she said, that is a very big deterrent on getting people from filing to stop them from filing frivolous shit in a
Yeah.
divorce case or in a custody case is to hit them with fees that you have to pay the attorney's fees for, the other party because you're filing bullshit.
Right.
Otherwise, people will just file shit all day. I mean, we've definitely had cases where there's frivolous shit that's been filed, and
Yeah.
it's frustrating trying to sometimes get it stopped,
Right. So Priscilla Thompson said, Bob, I need you to watch the plaintiff's closing to explain the admonishment this tool received. I tried to glance through it and find where they focused on the judge to see him saying something, but I couldn't find it. But it's too long of a closing. It's like an hour. But I wasn't interested to see.
Sassy, it could be Donna, or it could be the other person that they had the small hearing about this morning, wherein she was a correctional officer at the jail and they were trying to talk to her yesterday. She ended up not speaking with defense counsel. Defense counsel heard some kind of rumor that she was told that it would not be in her best interest to talk to defense counsel. And so they were like, they were trying to get the judge to issue a subpoena or see if they could issue a subpoena and if the judge would force her to come. Judge is like, well, they weren't on the witness list. Subpoena should have been done before trial started. So that could also be the person. I don't know. But it could be either or, I think.
I'm trying to see where this guy got.
So, Allie, have you done anything? So, Allie's been digging into the Austin Drummond case, and he does have court tomorrow. Do you know what the deal is with whether or not they're going to be streaming that hearing?
Yeah,
if you guys don't know
find
about
out.
Austin Drummond, he's accused of killing the 4 people down in Tennessee, and the baby was unharmed and left 40 miles away in a car seat. And the 7-day manhunt, they find him, they arrest him. He comes out after the fact and says that he was a Fed informant and that he was ratting out COs, smugglers, all relating to people getting drugs into the jails and the prisons, and that he was made the day of the shootings, and that he's claiming that he's innocent of the shootings. It's not clear whether or not he might not have been there. I don't know. There's a lot of things you can speculate on, but it's an interesting case, and Allie's digging in. So I don't know. Did you find out whether or not that's streaming tomorrow?
I mean, it's supposed to be streaming. I just don't know when it's up. I got to look back again. If it was in the morning, I thought I had it in my. Actually, I'm gonna try to do something. Talk to the people, I guess.
Yeah, I mean, that's the takeaway. That's a takeaway from this. Like, the short-sightedness of especially Donna. And if Harvey knew, especially Harvey and Donna, like they have life experience ad nauseum. They're supposed to have wisdom that you only get through living a full, long life. Like that's the only way you can get wisdom, unless you're smart enough to listen when people that have lived long lives are trying to impart wisdom upon you. But to be so short-sighted, to not understand what this would do, not only to their family in terms of destroying their family name, but to the kids that were affected, and I'm talking about Dan and Wendy's children, is so insane. Like how could she ever think that Dan being murdered would not massively impact, forever impact her grandchildren? And to not see that is so fucking stupid. It's so like, and I get like I don't even want to see the narcissist shit. Yeah, that's like, yeah, Donna's a narcissist. Yes. But it's just so short-sighted that you're too oblivious and so wrapped up with your own shit, your own wants and desires, that because you hear her with these kids. She absolutely loves the hell out of her grandchildren. So it just does not jive with me. It's like you can't. She clearly would go to great lengths in her mind for her grandchildren, but not have the wherewithal to understand that you have just fundamentally, and in the worst way possible, changed the arc of those kids' lives. It's just, the whole thing's insane. It's insane. I just don't get people, honestly. If you've got And that's why, like, early on, and I'm still not sure where Harvey's at. I don't know if he knew before. He definitely knew after. At the time of the bump, when he's sitting in the restaurant with Charlie, he clearly knew that there was some kind of squeeze going on, whether he was led to believe that it was they were extorting him, or if it was extortion as continued payment or additional payment. I don't know. I don't know. Georgia has a better idea about that than I do, or than any of us do. Like, we're all out here speculating, like trying to parse every single word that everybody says in every single interview. Exactly. Crystal's like, yes, Harvey knew for sure. I mean, how do you say that? Like, you don't know that. I mean, he might have. But my point is, if you're Harvey, if you've built this life over 78 years and your family legacy is being put in jeopardy on some bullshit, like, I just find it hard to believe that Harvey wouldn't have, unless he just had no ability to be able to reel Donna in, which certainly is a possibility. Like, my grandfather could not reel my grandmother in. Like, when my grandma, my dad's mom, when she was on one, she didn't give a shit what my grandfather said. It's like, when she was on one, no one was telling her shit. And that was like, obviously she wasn't doing insane shit like this, but she would say things, she would blow up relationships in the blink of an eye, if she felt that somebody had wronged her. And, like, my grandfather didn't have a damn thing to say about it. Couldn't stop it if he wanted to. I don't know if that's the relationship between Donna and Harvey. I mean, to me, from the outside looking in, it seemed like they had a pretty equal footing in terms of that relationship. I mean, they traveled a lot, but you can't tell from the outside looking in. You know what I mean? He absolutely loves her. Still loves her. He's there every day in court supporting his wife. No matter how bleak it looks, he's still sitting in there. He's still sitting in there when they're putting up evidence that would seem to be inculpatory as to him. Still sitting in there. So, I mean, clearly there's no question about the legitimacy of that relationship. But again, that just begs the question. If he knew, why wouldn't he have shut it the fuck down? Why wouldn't he have said, Donna, no, or that is insane. You're going to ruin everybody's lives. Everybody that this touches, all of the lives will be destroyed. You're going to destroy our life. You can't just assume you're not going to get caught. You ain't that clever, yo. Yeah, I don't know. I don't know if Wendi played all of them. Like, what are you basing that on? Jay's videos? I know Jay's hot on Wendi, but like, Jay doesn't know Wendi from a hole in the ground. None of us do. None of us know. Like, and I get it. I understand the concept of having a hard time believing that Wendi didn't know. As much as I love Rob, every single family has their own issues. And again, we are looking as complete and total strangers in on a very intimate thing that happened between these family members, and we were getting very limited information. I'm just saying, I have no position whatsoever as to whether or not Wendi did or didn't do anything. I can look objectively at the evidence that they have circumstantially and think that, yeah, she definitely could have been a part of it. But there's also things that I can look at it and say, I'm not so sure. But like, in terms of Rob, I mean, we don't know, as we sit here right now, exactly what caused him to disengage from his family. I mean, it might not be one thing. It might be all kinds of shit. And I mean, there can be some animus there. You know what I'm saying? I mean, clearly Charlie and Wendi had a much closer relationship than Rob and Wendi. I don't know what the gap in years is in their ages, but I don't know. I'm just saying you got to take everything with a grain of salt because we really don't know shit about these people. That's it. Yes, I've seen the police interview of Wendi, and I've seen people evaluating it and trying to parse what people are saying and blah, 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 blah. I mean, Marissa, how long have you been watching my channel? Until you've walked a mile in someone else's shoes, you don't know shit. I give very little credence to body language experts. I give very little credence to the ability to be able to know what somebody is thinking based on something that they've said. Can you maybe get clues? Yes. But you know, there is no proper way to respond to trauma. We're all fucking different. We all have our own traumas, our own life experiences. We all deal with things in different ways. Like, no one's ever going to convince me that there's a right way to do something when it comes to anything, any kind of emotional response. You have no idea what has gone on in other people's lives for you to be able to sit with any kind of confidence and say, oh, this is for sure. In my opinion, like I will not do that. I'm always cognizant that people have their own shit and that affects the way they respond to anything in life and what's proper and what's not. It's why, like, 911 calls always fascinate the hell out of me, you know, because that is, frankly, in theory, the most raw you're ever going to hear somebody. If somebody happens upon an emergency situation wherein it involves somebody that they love and that call is made, if it's not premeditated, you know, and that's what people are trying to figure out. If people are like, oh, well, that's some bullshit. Like, I can hear it in his voice. This guy's full of shit. No, you can't. I don't know a goddamn thing about that person. Like, there is no this is the standard how everybody's supposed to act when they come in. Like, no, it's not how this thing works. We're humans. We're all different. So it's just, you know, it's like, but I love the exercise. I'm certainly not discouraging anybody from thinking that Wendi needs to burn in hell, because you know what? Wendi very well might have had all of her hands, all of her fingers in this. She might have been the absolute puppet mastermind behind all of it. 100%. I'm just saying, in terms of a court of law, then, you know, you're going to have some powerful evidence together. But that being said, the fact that they're knocking the dominoes down when it comes to the Adelsons helps in a case against Wendi, because I think that most jurors will feel the way that most of us feel, that there's no way that this shit went down without Wendi knowing about it. Like, I'm never going to believe that. And I think that most people feel that way. Yeah, Danielle, well, my counter to that is that's fucking stupid. If she knew about it and she had a hand in it after she so carefully kept her name out of her family's mouth and out of any kind of text communications in terms of her having knowledge, then if she did all that and then drove by the scene, then that's incredibly moronic. See, like, that's the part that I have a hard time reconciling with her driving by the scene. It's so it's so profoundly stupid. If you were to believe that she knew and she was able to keep herself out of all the phone calls, all the emails, all the text messages in terms of her having any knowledge, and she's going to turn around and drive by the scene, it's hard for me to reconcile that with everything that I just talked about, her keeping herself out and distant, and like I'm manipulating the situation so that it all happens, but no one's gonna fucking know because I'm the smart one. But then she drives by the scene. I'm having a hard time with that one. I'm having a hard time. You have to think a little bit beyond just the fact that she drove by there and the timing of it. You know, like that. It's nothing's as if you have a skilled defense attorney in there, I'm tearing that fucking apart, that concept. And I'm going to establish that Wendi, every single time she dropped the kids off at Dan's or every single time she picked up the kids at Dan's, that was her route. That's just the way that she's used to driving. It's like I told you, Allison and I have two ways that we can get to 88. Allie always goes.
Hey, are
up
we
the
live
road.
with this? Because I saw court.
Oh. Okay. Boy, I was on one. Sorry. No, I mean, it's live. Oh,
What?
wait. It's pause, though. Sorry. Sorry, just kidding. Oh, yeah.
Counsel.
Okay.
All right. Good boy.
Oh, it sounds like she's going to get admonished right now.
Give us a bloop.
What? Okay.
So that
we
we're
have no
there.
Blooping.
Well, I don't want to watch the seal again.
I love the seal. Only seal. Only seal.
So, by the way,
Oh.
Drummond is tomorrow afternoon, 1 o'clock, whatever Tennessee time is.
I think it's half and half. I think there's some Central, some Eastern. Let us know if you're from Tennessee. I think some of it is Central, some of it's Eastern. It might be all Eastern. I don't know.
Lake.
2 matters.
Okay, there we go.
All right, 2 matters to briefly address before we bring the jurors on. The first concerning the
It's the same time right now as it is
first
here.
concerning the waiver of attorney-client privilege as to the testimony of Mr. Scalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call?
Yes, Your Honor, the waiver is specific as to the counsel that our client received from Mr. Scalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf.
Indicate what it's limited to. Yes, my waiver is limited to what my lawyer just said.
I mean, made her thoughts about what?
I think the travel. I'm assuming.
I mean, Wendy's actions in the relocation, the divorce.
Mrs.
All right, hold
Adelson,
on.
do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that we discuss after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No.
Your Honor. Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also
Jeez.
matters of impeachment and bias.
You trust in Zellman So this is a very, so clearly they're putting on some attorney that gave Donna some counsel. Okay. And she's waiving privilege as to certain aspects of that discussion. Do you trust these two? Because once they open the door, Georgia gets to fucking kick it in and ask whatever the fuck she wants as to that subject matter.
Well, the judge did just say, if it goes beyond the scope I just heard, I'm going to make the jury leave. So even if he fucks up, it sounds like the judge is going to be like, that was more than what she just said. So
Well, but he's also giving a open the door admonishment here too.
Oh, all right.
I thought. Let's just listen to it.
Two that exceed the scope. At that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
Tricky minefield. Depending on what she told this lawyer.
Concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
And?
If I may judge, the issue is that we.
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Whisper in his ear, Jackie.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed. So we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what is actually coming in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. The defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know that we will get started momentarily.
They're still hoping this other like witness they were able to subpoena? I don't know. Do we have any
Tell you
blooping?
what,
Bloop,
Judge
bloop?
Everett gives 0 fucks.
And is it boosted? Yeah, it looks like it's
Yeah, it's
boosted.
boosted. It's boosted.
Hey.
Why did you have a hard time hearing it?
I mean, it's not as loud as I'd like it.
I was kind of having. That's what I
Bloop,
was
bloop,
saying. I was
bloop, bloop.
having a hard time. No, you had me eat up all the blooping.
Oh,
Remember?
well, don't pause.
Remember? No, I'm kidding. There's a little
Oh.
blooping. Just trying to punish you for your pushiness about my blooping. All right. I mean, let's talk about this though a little bit.
I want to hear what she says.
I mean, the judge is right though.
Yeah, they get plenty
mean,
of time.
there is
They're
the
trying to say there was today. All the witnesses that got on today. We need to discuss that as well. But no, they had time.
Here's the problem. If you're telling the truth on the stand, you don't have to prepare that much. If you're trying to make up bullshit to deal with like all the things that the state has brought up, it's a little more problematic. Then your lawyer does need to go through each and every point.
I mean, your lawyer always needs to go through each and every point, but I think they're not saying prepare her to testify. They're saying just to get an answer on whether she should testify or will testify. Or let's hear what she's going to say.
Yeah, it's more than that.
Yeah.
It's more than that.
Audience concerning things that are said by the defense. And although the proceedings are public,
That has not stopped peanut gallery from their comments and laughter.
We heard this.
We are respectfully requesting that the court allow Miss Adelson to participate at sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
His approach, we are not going to do this for very long.
I thought you were letting her come. Oh, they are.
They are.
All right, bloop, bloop.
I don't have much blooping.
I know, but
I don't have much.
Give us whatever you got. That looks
I mean,
live.
this is going to have to be a talking. We're live.
Okay.
Who can read lips?
Somebody read them.
Somebody can read the lips.
He's saying, well, she's insisting, and we think, fuck no. But, there's this person in the jail we still haven't gotten a hold of, and we really want that one to come in. So she's concerned, like,
Is that you trying to read lips?
I mean,
all right, answer that question, babe. So she's got use and derivative use immunity. So simple me.
The immunity doesn't change anything she can get charged with. It only changes that they can't use what she testified to against her.
Right.
From her words.
From her
or
words.
Derivative if they didn't already know it.
So I mean the long and the short is like, so they can use anything that Wendi said in her police interviews.
Yeah.
Anything that she may have said that was damaging to Jeff Lacasse.
Yeah.
Like they just can't use the things that she testified to in any of the trials.
Right.
Can't turn around and use that as evidence in a case against her. But everything else is fair game. You can use the fact that she drove by the crime scene.
Yeah.
You can use the fact that she was taking a route that doesn't make sense because there's a shortcut.
And they can impeach her with it if she says something different.
Right. Well, that's if she testifies.
Yeah. If she testifies.
So Wendi did not. Who gives a shit?
I mean,
like that.
She's
like
just
that,
saying.
I mean, to me, like again, you're pigeonholing people into how they're supposed to act in a moment. I mean, I think that there exists a world in which Wendi couldn't stand Dan?
I think this person's saying like she should have feigned sadness. So driving by the crime scenes within her level of carelessness, like she should have pretended to cry at least.
Oh, I see. I see what you're saying. Man, I thought I just saw something where she was hysterically crying in a police interview. Maybe that was something different.
Man, I wish we knew what was happening.
Be a fly on the wall.
What could they be saying? He said, Your
All I
Honor.
can tell you is if they charge Wendi, I'm here for it. It's like, because like that will be to me, depending on what other evidence that they have that we're not aware of, because we have definitely gotten new evidence in this case. Some of it damaging to Wendi. So you have to assume if they bring it that there's going to be more.
Well, so the attorney said to the judge, Your Honor, we need to have this sidebar. We need to have Donna involved in the sidebar so we can discuss issues that bear on her decision. I'm trying to think like what are these issues? Like scope. They could be being like, well, look, we need to know if we ask this, are you letting the state ask everything? And she wants to know scope. What type of thing are you going to say? Well, that's bias. That's impeachment. That, they get to ask that kind of shit no matter what. Like, I don't think you can get up and ask the judge for like, hey, can you tell my client legally, if she says this, it's opening the door to that, or you're not going to allow this, you're not going to allow that.
That's what I'm talking about. It's like a minefield. It's like a minefield. It really is. Like this lawyer getting up there. I mean,
I don't know if you answered this. I play a lawyer on YouTube. Was Charlie's defense team this bad too? And I'm assuming she means as bad as
Ashley, I'm at 55. I'm not putting myself any lower. Maybe lower your volume.
Let me see what I'm at. I'm at 54, so we should be about the same.
You sound good.
All right, here we go. Let's go.
It's as high up as it goes, Ashley. I'll try this booster. Let's see if that's better when they talk.
Teasing us. What a tease.
Are they bringing the jury in?
What?
Is that what they're doing?
What happened to admonishments? Why do I hear myself echoing? Wow. We'll never know. Oh, he's giving them time for something.
Everyone can be seated. Members of the jury, I hope you had a restful lunch break.
Sounds the same to me.
We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state? Defense 50 is admitted.
Thank you. At this point in time, the defense would call Marisol Descalzo.
Marissa Scalzo. Oh, maybe this is the former lawyer
Please
situation.
raise your right hand.
I think so.
Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated. You may inquire.
Thank you, Your Honor.
Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her
After her arrest.
sometime in 2022 through maybe 3 months after she was arrested.
Oh.
And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
What? Kind of.
Concerns about Mrs. Adelson's mental state, yes.
Yeah. Can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Did
What an
that cause you
open-ended
to
question.
take
Jesus.
Any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Grashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
In a non-extradition
At that
country.
point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
And specifically, there were no warrants for her arrest.
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson. So I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
So
Did you
didn't
advise Mrs.
confirm.
Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making a serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
Oh, he's done. So I got the impression she actually called the prosecutor and was like, hey, my chick wants to travel. Is there a warrant?
Cross-examination.
Doesn't sound like that happened.
Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
Sometimes.
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
I've made arrangements with law enforcement.
So it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended.
Correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to, I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay, and you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago.
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Never.
No, I had an
Not
attorney
in a million years.
relationship with her, and I didn't think that would have been appropriate.
Sure.
Highly.
Why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay.
There you go.
Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you.
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overruled. The witness has opined on this matter.
I'm not law enforcement, so I'm not sure. And I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
I've never been law enforcement, so say the same thing.
I was law enforcement, and I heard a target of investigation discussing a flight.
As her attorney,
okay,
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I'm not law enforcement.
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second.
Oh, this is going to be a short witness. Wonder who they have next.
Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender?
I don't know.
Not as to a bond.
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Direct examination.
Thank you, Your Honor. Mr. Scalzo,
Prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
Nothing further.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
Doesn't change the fact she was looking for it.
she might be able to get the early flight this evening.
You are released. Please call your next witness.
Just a moment.
What you got?
Defense would call Sarah Newhouse.
Miss Newhouse, have you been sitting in the gallery during today's testimony?
Sorry, she's already in the courtroom.
Oh, she's in the back row there, Judge. Come on up.
The price is right.
Ba-bum-ba-dum, ba-bum-ba-dum, ba-dum-ba-dum, ba-dum, 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 ba-dum.
Probably just got us a copyright on that song that somebody did that's used.
I mean, it was pretty on point.
There she is.
Please come up to the witness stand. Raise your right hand down. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendi Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendi Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendi Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendi Adelson called her mother?
It is.
Okay. When Wendi Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
And
what was it?
Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
And at this point in time, I move into evidence defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that, objection.
A lot of qualifications.
Well, there's just.
Members of the jury, we're going to take a brief break. The bail will take it in the jury room.
Babe, are you there?
Yeah.
I missed what prompted that. That's all right. They'll say it again.
Did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
And at this point in time, I move into evidence defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that, objection.
A lot of qualifications.
Well, there's just.
Members of the jury, we're going to take a brief break. The bail will take it in the
All right,
jury room.
babe, bloop us. So she wants to review it. She's got her headphones on. She is reviewing.
We live.
And we live. Hey, what does Shady NCDA get?
Aw, family hug.
Robin loves Mike forever. Love you guys. Logo. Alibaba brand. Must be one of those little emojis.
Yeah, it's the Bob brand emoji. So back here, it spells it out what the emoji is. We don't get to actually see it.
Yeah. Yeah.
When it's a custom. Harvey, permafrown.
Well, I'm interested to watch this. All right, she's done. Do you have an objection? Wait, she's talking. How come we can't hear her?
It includes
Oh.
Wendi Adelson saying this is the worst day of my life before the call connects. And then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand they don't tend to publish it right now. So subject to those objections, no objection to the exhibit once those things are removed.
Mr. Zellman?
As I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. Bring back in the jurors.
Okay, so now don't forget that what you just said is you're going to redact it. Oh, I don't get when he's doing that. Like, this isn't this like the end of their witness list? Hey, we got that guard.
Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendi Adelson, her daughter, presumably does know.
Correct.
Do you remember Wendi Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the
Right. Are you fucking kidding me, Georgia?
No further questions.
Redirect.
Wow.
Ms. Kappelman.
Members of the jury, you are to disregard the last question of the prosecutor is to be struck from the record. You may step
That
down.
was dirty
The witness
pool,
be
Georgia.
recalled.
Disappointed. Wait, what? Oh, is this witness?
To your exhibit, do you wish to publish or just leave evidence?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the two references. That could just take a few minutes.
Well, the jury will have a brief break and then we'll take you to the jury room once again.
Wow, Georgia. Wow. That's all I'm going to say. Literally just asked the judge to just asked to have that redacted.
Donna, this is your conscience. Don't be a fucking idiot. There's no way you can testify in court. They won't.
Please make all necessary redactions and changes at this time.
Why have we decided, damn it, what happened on that sidebar that we didn't
Sidebar.
get an admonishment?
Everybody loves a sidebar. Everybody loves a sidebar. Yeah, we have no blooping, thanks to you. With your pushy
And you're
blooping.
buzzed right now.
Okay.
I'm just saying, so we don't, you know.
Here, Jackie's trying to talk her up
Why do they have the mics off?
because Jackie's trying to talk Donna up. I don't know. It seems like Judge Everett's saying something hilarious. So
You sure you didn't turn down the volume somehow?
yeah, I'm pretty sure.
Okay.
Pretty sure.
Oh.
Yeah, turn it back on.
If there are no other witnesses for the defense,
Oh shit.
it is time for the decision to be made.
It's time.
Oh
I
shit.
tell the court that co-counsel and my client are deep in conversation. Concerning
I
this.
am capable of seeing that, Mr. Zeldin.
So I guess they never found that
Narration
guard.
is needed.
Will she or won't she?
What's she gonna do? What's she gonna do? So much more interesting if you testify.
So much more. Way more interesting if she
This
testifies.
is Cattleman wants the defense rest. Is the state intending to place or put on any rebuttal case?
I think not. If they rest without calling any further witnesses, that could change. If Mrs. Adelson decides to testify.
Don't forget, you still need to publish that.
At this
Redacted.
point, I do need a decision. Mrs. Adelson, please rise.
Oh boy.
You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of this.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify
Just
or
say
whether
yeah,
you will not.
and then
I
think it
cannot
over.
make you testify. Your attorneys cannot make you testify, but ultimately you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorney.
This has already been discussed, ma'am. What is your choice?
Just say yes. And then you can think about it tonight if they don't put you on right now.
Judge, since I was handling the prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
2:06, my time.
You cannot get higher drama than that right fucking there. Donna, like,
She's like, Your Honor, give me more time.
he's like, no, that's it. Shit or get off the pot. It's done.
Question becomes, is he
But
making
dude,
her?
It's high drama.
Is he making her get on the stand this second? Because if not, she can just say yes and then tomorrow change her
It's
mind.
4:06.
Right. No, it's
They have
3.
an hour and a half.
It's right. It's 3:06.
Oh yeah, it's 3:06. Yeah, there's 2.5 hours of court left. If she's getting on, she's going on right now.
Mm.
Like they would have said, all right, well, yeah, she's gonna take the stand, but tomorrow. So like we'll come back tomorrow morning. She'll be on the stand then overnight. She can change her mind. They can't force her onto the stand. Yeah, no, I think it's like you're getting on there now, but that is high drama. She's like in the hallway or wherever they put her with Jackie. It's like, I can't believe the judge keeps giving me 5 minutes to make this decision. No, Donna, you've had a year plus. You've had Carly's trial to understand whether or not you're going to do this. All that you had to figure out was what they were going to put on and evidence against you. And that's the only consideration. Is there any way that you could talk your way out of it? That's it. That's
Or
all.
like
you
what
have to-
everybody's saying, she fakes a medical emergency.
Oh, come on. That'll be like the fucking principal and Ferris
gotta-
Bueller roller,
I'll edit banner.
huh?
The banner.
What banner?
Donna deciding.
Oh, deciding her fate.
5 mins from, what time is it there? 3:06.
Trio 6.
Oh, I got the time wrong. Oh boy. Did I spell decide? What? I can't even see what I wrote. Oh, I didn't put it back. Mm. Mm. My stopwatch says 2 minutes, 10 seconds.
Oh, we got some more Venmos in. Pamela sent us 25. Thank you for pausing while chatting today. Love you guys. Thank you, Pamela. We love you too. And Gloria sent us $5 for the wheel.
We're live, right? There's not a bloop to be had.
Not a bloop. Oh, wait, we have a bloop.
Oh my gosh.
How exciting. Now we're live. We were exactly 10 seconds. Renee paid us $50.
1
Yeah,
minute.
man, I love watching yours and Allie's commentary on the Adelson trial. As always, you guys rock. Family hugs. Thank you, Renee.
Family
hugs
hugs.
to you. And Danielle, she sent us $15. My comment the other day, feeling for the kids after my dad's murder going unsolved, and my mom and her husband.
Can be seated.
Wow.
Oof. Man, I had some seconds left, Judge.
Mrs. Adelson, the extra time that you have been provided.
I had a minute left.
Conclusion.
He jumped the gun. Unless that bloop was more than 10 seconds.
We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move
How do
on.
you contempt her? You're going to give her time to think. You're going into a cell now.
Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Oh.
Wow.
Very well. As
This
I
time.
previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record.
No, they can publish their thing.
Indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
Donna, that's it. It's not at this time. It's like you've decided.
Wow.
It's over.
Wow.
She's gonna.
She shocked the world, babe.
Oh, yeah. And she's gonna be forever hating that decision when she's convicted, even though it's probably the right one. You know,
Yeah. Well, yeah,
she's
she'll always
gonna-
question it. She'll be like,
Yeah.
if only I had gotten on the stand, I could have told these people. Who are these men?
Don't forget, you still have to publish your shit.
Yeah, publish your shit.
Gonna play
Man,
that
I've
video.
got this bag of crunchy ass chicharrones. You were wondering what I was doing off camera. I was crunching on these very, very
All right.
loud crunchy guys.
Anything yet?
See, I will tell you though, Donna did listen to her conscience. I mean, there's no disputing that.
I think she listened to her lawyers. Conscious
What?
was definitely saying you can explain it.
We might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to reach read to the jurors. Or we can decide the language now. If you find that more acceptable, it's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that,
I thought she was.
prepare the stipulation in writing that needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. And we'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
All right. Well, we need to.
Concerning whether or not we are going to rest at this point.
Do you have another witness to call?
That's what we need to discuss, Your Honor.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness.
They're trying.
They're trying to buy time. They're still trying to buy time for fucking Donna.
Yeah.
You don't think he knows? You don't think Everett sniffs out your bullshit, bro?
He's like, I don't want to rest. I can't rest. I can't rest. I just can't rest because she wants to change her mind.
Because the point is, even if they're like, once the defense rests, that's it. The
Right.
evidence is closed. They can't then turn around tomorrow and be like, oh, because he's obviously going to give them, the jury, the rest of the day off. They'll come back for closings tomorrow. If the evidence is closed, I mean, I suppose they could try to make a motion to reopen the proofs, but the judge is going to be like, nah. Especially if it's just to get Donna to testify. Yeah. What do you say? What say you, Harvey? What say you?
Who can we put on to kill 2 hours?
Wow. Should we put Harvey on just to hem and haw?
Well, he's been sitting in the courtroom, so that sequestration violation would be. I mean, they should have taken longer with their shit. I was surprised they weren't dragging it out with the lawyer and the.
Yeah.
I was actually thinking that they're not really dragging this thing out.
Bruce, like, man, I wanted that bitch on the stand. I wanted to hear her bullshit. You know that.
He must have told Donna. Because Donna says at this time, that's why I'm like, they must have tried to make it seem like they're not resting. And then the judge turns around and says, we're coming back for you to rest. I'm like, wait, Donna said at this time, she thinks she's got another time.
Yeah. Man, oh man.
Your Honor.
Can't beat the courts
She wants
for
to
high
testify.
drama.
She wants to testify.
The human condition.
At
like
this
is
time,
technically more time for her to think right now.
Right.
This guy's like Selman's just shuffling papers around. Oh, wait. Hold on. Wait.
Donna's like, he did rip me 1 minute. That was the first 60 seconds.
Hold on, Judge. I'm still looking.
Who's in the hall, counselor? Is there someone in the hall?
Hold on, Judge.
He's got to be like, we think we're going to have this guard tomorrow. We can't rest.
The ever watchful eye.
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualified or hearsay exceptions. The state's indicated that they're objecting. If I could just have a moment.
Boy, oh boy.
I don't know why they gave up on this guard thing. They could have bought them the rest of the day. Should have at least asked for it. seems everyone has forgotten that they're supposed to play that video for the judge, for the jury. They're supposed to publish their last exhibit, 71.
Donna, this is your conscience. I've changed my mind. Don't be a fucking idiot. You have to testify. They'll never buy it otherwise, Donna. I've made a terrible mistake. Disregard what I said before. You must testify. Conscious out.
I mean, is she doing a lot of thinking right now?
If only she had
Oh,
a
she's
conscience.
taking out a pen. I want to testify. Pass it over. I just got a really loud message.
Oh, Donna, oh, Donna, oh, my Donna girl.
Do you have another? He's like, what are these idiots doing? Like, they don't think they're getting 2 hours out of this, right?
Do they think they're going to be able to squeeze 2 hours out of this?
Look, he's like,
little-
what kind of bullshit y'all doing right now? Let's go.
Gentlemen, concerning the items, we do need to move on so that ruling can be made.
Donna, I know I told you that, like, maybe you could think about it tonight, but you can't. So, are you sure?
Thanks, Mary. And you're on the wheel.
You guys, I think I need to testify. What are we gonna do here? Can't you just try again? Drag it out till tomorrow. Just try again. He's like, y'all gonna slap you in the forehead.
Your Honor, yesterday, the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar. That is, I believe it's states 51. No.
Timing's everything. Timing's everything, Laura Lee. Donna's deep in thought, bro. Deep in thought. Deep.
Cattlemen, concerning these items was the state's argument.
State's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar. It's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents. The state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023, where my client lists those very same items to get prices to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes.
Who was going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state. It was
I
seized by.
believe as the inculpatory matters, yes. As to whether or not she is planning to sell something in January of 2023.
She's like, see, I gotta testify.
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided.
He's right. He's fucking right.
Previously, not for the truth of the matter asserted, not that she was.
Hold on, these are not recordings. A book with several entries is somewhat different from a recording.
Nope,
As it
completeness
relates to
doctrine.
recordings, the rule of completeness, I believe, serves a different
purpose.
purpose. In the
Yeah. End of writing. End of writing, Your Honor.
Each page of this planner, all of the information is not inculpatory. So to that end, what witnesses laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023
She could change her mind right now.
For identification and it's in the clerk's possession. So these
Oh,
are
yes,
the
you can.
pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit.
Well, then we need to reserve
research. But again,
her.
Every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just one.
He needs to say right now this ruling, impacted our client's decision not to testify.
Yeah.
He'd say it right now.
Yeah. Yeah. Somebody had asked if we think that, if we think that Donna's been involved with her defense. Are you fucking kidding? To see the emails between Donna and her daughter in her case. Yeah, Donna's been up their ass. She's a micromanager. She's the meddler.
Excuse me, Your Honor. The
Say it.
argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I sent this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband and the specific entries that she made identifying the tasks that she was going to carry out for that.
Who's your witness?
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Is Kappelman any additional argument that you have already made?
The only entry from the 14 planner that was admitted, that has been admitted so far in this trial, is the page that shows
The license plate number.
license plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object.
That's right.
In addition, I think this exhibit is
She's
in a
right
little
there.
bit different posture because the 2014 planner in its entirety has not been identified at all.
Mhm.
That page was identified. The 23 planner was identified as by a witness as it being seized from the residence.
I will reserve ruling as the 2014 planner as well.
Say it.
Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor, and for the record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
Damn, they missed a fucking opportunity. He's gonna make them.
The state has made the, I want to check the redactions on this video.
Oh, so at least he remembers that he still needs to
I
publish
believe
that.
this is just being admitted without being published, correct?
That's correct.
Wait, it's not being published?
Jurors are fine to come in.
Why the hell is he admitting something he's not publishing?
For the purposes of them being able to argue it in closing, I guess. I don't know.
But why not publish it?
I don't know. Let me see. I'll move the captions over here.
Wow, they missed a huge opportunity to extend her time to think about this testifying thing. Because it sounds to me like judge is going to make them rest right now, but then we'll give them the opportunity to put back in the stuff that he's thinking about. That's what I heard. I don't know. We'll see right now. The defense might think they just bought themselves a minute, meaning
Everyone can be
overnight.
seated. Defense may call its next witness.
Oh boy.
All right, at this point in time, the defense rests.
Oh, he rested.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties. And from there, tomorrow, you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
Those additional planner pages, I think, are important, and I think he should be letting them in under the completeness doctrine. He seems inclined not to, for as it relates to 2013, because it gives context to the other entries. They are able to misrepresent those as only have occurring afterwards. But the
Please open
2014.
your copies of the jury instructions. My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
No, Your Honor. No, sir.
3.2, Statement of the Charge. Any requests or changes?
Not from the state.
Your Honor, the only request that I would make is that the name of my client and the names of the charges do not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note. We Moving on to 7.1, Introduction to Homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
As to the next paragraph concerning lesser includeds, is the defense asking for all category 1 lesser includeds?
Man. I don't know what that guard was going to say. They didn't bring it up again. They didn't ask for the rest of the day. Could have bought some time that Donna clearly wanted and needed. And the defense fucked it. They dropped the ball there. I don't know if it would have worked, but they should have at least asked the judge that if these aren't getting in under the completeness doctrine, that has a direct bearing on my client's decision on whether or not to testify.
Which is a valid argument.
Right. May have forced his hand to rule right then and there. And
Yeah.
I also would have said, also, Your Honor, given your comments about it being more applicable to a recording than to a written instrument, I would like to present Your Honor with case law on this issue that would indicate, that would support our position that applies equally to a writing, and not only that, to this writing under these circumstances. He may have pushed back because, like you said, he knew that they were stalling. You know, he might said, I'm going to give you 10 minutes to find me a case, and I'm going to rule right now. And that might have come back and bit them right in the ass too, because he might have ruled differently if his feet were put to the fire to rule right this second. But I'd say, in my legal opinion, the 2014 arguments they made for the 2014 calendar are without merit.
Request for manslaughter, lesser.
As to the second degree, lesser, are you requesting that as well? It's category 1.
With the
Either she's not involved, or
it's category 1,
or it's first degree murder.
Carries the same penalty, so we are not requesting second degree.
Is the state requesting second degree as a category 1 lesser?
Yes, sir. Yes, sir. We'd be requesting a lesser.
How the hell's it hit
Well,
for
all
hire
category
manslaughter?
1 lessers will be given. Second paragraph will read in the introduction, first degree murder includes the lesser crimes of second degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. I believe the indictment refers to the victim as Daniel Markel. Does either party have a preference?
To conform to the indictment, we would request his full name, Your Honor.
Acceptable.
If you find Daniel Markel was killed by Donna Adelson, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these.
Come on, no.
Not entirely certain we have any evidence in the record that would support giving them, but as I'm party requesting.
Just a moment, Your Honor.
No defense. How the fuck can you ask for? I don't even know how they can ask for manslaughter, to be perfectly honest. Yeah, it was justifiable because he was a jerk in a divorce proceeding. I mean, no, you can't ask for this justifiable.
Mr. Evans, Ms. Koppelman.
No objection removed.
Just the definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers. Final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser included crime. As to count one, the state is only proceeding on the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed. The elements of first-degree premeditated murder. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
Just the stylistic issues that we raised previously.
Very well. Instead of caps, they will be in upper lowercase. Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given. The question of premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation, that will be removed. All right, instruction 3.4. This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
Yes, sir.
All right, 7.4, second degree murder.
That's for real.
Introduction to homicide will be given. This portion of the instruction will be removed. To prove the crime of second degree murder, the state must prove the following three elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was an unlawful killing of Daniel Markel by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. As to the definitions, I believe act is repeated. Is there any objection to this stating an act has been previously defined above?
I don't have a legal objection to that, Your Honor.
Mr. Evans?
No objection.
Where'd this other guy come from out of the blue?
Who?
The prosecutor.
Oh, I don't know. Looks like Morrissey.
George is like,
The
I don't
second
do jury
definition, an
instructions.
act is eminently dangerous to another and demonstrating a depraved mind. That must be given. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legally adequate provocation. That will be removed. The next lesser, 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. As to element 2, which theory is the state proceeding on?
I thought it was the defense's request.
Well, A and B will be split by an or.
Right, so they're going to include both options.
Donna
The
Adelson
or.
intentionally committed an act or acts that caused the death of Daniel Markel, or Donna Adelson intentionally procured an act that caused the death of Daniel Markel.
See, that would cover asking to get beat up, but they murder instead.
Yeah.
Right. Concerning the state versus Spencer italic, that will be removed.
And my understanding, Your Honor, is given the fact that the defense has not requested that instruction, has agreed there's no legal basis to give instruction, there is a concession that the homicide of Daniel Markel was not excusable or justified.
Zellman, do you need to be heard concerning the concession that it's not excusable or justified?
Not in the facts of this case, Your Honor.
And defendant agree with that concession.
Very well. Mrs. Adelson, do you understand what is being omitted from the jury instructions? Go ahead.
The judge can always reopen proofs if the defense asks, but that's by no means the norm.
No,
Mrs. Adelson, do
it
you
is not
understand
going to
what
be
is
to let
being
her
omitted
testify.
concerning whether this homicide was
Chance.
justifiable or excusable? As to that concession, do you need anything else that you need to discuss with your attorneys?
She said yes.
Please discuss it with them now.
Thank you.
Hey, guys, I fucking want to testify. I mean, it's possible some scenario could be said where, you say the right magic words.
No
and-
way. I mean,
Dang.
I would agree with you if he hadn't been so adamant. Like in his mind, she's had a long, long time to figure this out, even during the trial.
Right.
Like in his mind, they should have been there all night talking with her, talking through it. They knew this day was coming. They knew how many witnesses they had lined up. Like, because you're right. I mean, you can come in there and you can make a compelling argument. They could open proofs, but in this situation wherein he has put her to the fire, put her feet right to the fire, there's no way he's doing it. I mean, like, even if she's crying and hysterical.
Well, she says something like, my lawyers, when they came to visit me, they guaranteed me I'd have one more day to think about it. I was too stressed out. I wasn't ready. I don't know, like enough. Like I had previously been insisting. They really, really pressured me. I was so pressured.
Yeah, I
Also,
mean, if
you
she throws
understand
her
the
lawyers
concession
under
that
the
is
bus,
being made as a
maybe.
justifiable and excusable homicide. You are giving your consent to this. Let's move on at this point. The paragraph that states every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm. That violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard?
We can carry her off.
In order to convict of manslaughter by act, that paragraph will be given. The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No.
There you go.
The definition of procure will be given, and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The two elements are static. As to the portion below that is italicized, or any of the italicized portions being requested. I believe as to the first paragraph where it says attempted homicide cases,
We're not measuring this for completed offense.
say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for.
Correct.
Completed offense.
I believe that instruction must be given for first-degree premeditated murder, and all references to attempts of any other sort will be removed. The state must prove the defendant intended that the killing of Daniel Markel occur. As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markel.
Your Honor, I think under that, the manslaughter instructions, or manslaughter needs to be included.
Concerning whether an intent was necessary for manslaughter as well, Mr. Evans.
Yeah, you have to intend the act, but you don't have to intend to kill.
As to that inclusion within the principal instructions, the defense wish to be heard.
Just a moment, Your Honor.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not inviting error?
No.
It's fine.
You get nothing and like it, sir.
So you can contact me on that, Judge, and I'll let you know hopefully later this evening.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as a second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. All right. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those? For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. Excuse me, I haven't moved down the principles already for the next time. So I ask yes or no. There's no evidence that the defendant in this case actually possessed a firearm, so no, we're not requesting.
It will be removed. (3.5) sub B, principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all things the person who was promised or received the money did if the state proves beyond a reasonable doubt. Then elements 1, 2, and 3 are to be given. As to the bracketed portion of element 3, the offense that the state is asking for to read in element 3, would this be first-degree murder?
I'm sorry, Your Honor. Can you say it again?
Element 3, the bracketed portion, it says crime or attempt. The crime that the state is requesting, is that first-degree murder?
Yes, sir, but I don't believe it. I don't think it asserts crime. I think you just leave the crime was committed by another person.
So not a specific crime, just crime.
Yes, and I think that's why they have attempt.
Unless you want the offense to be named, I will leave it at crime.
I think this crime is the appropriate one given the standard instruction.
I'm gonna look at the standard reading, Your Honor.
The other person that is referred to in the bracketed portion, or any specific names being sought, or just the other person?
Just the other person.
I would ask that the individuals, Sequestration Garcia and Luis Rivera, be named.
I believe within the indictment, the named co-conspirators are Charles Adelson, Catherine McVanois, and or other persons.
For count 1, Your Honor, there's no one identified.
Mr. Evans.
You, for principal instruction.
3.5 sub B, element 3.
Yes, sir. What I'm saying, for principal instructions, you do not have to allege it in the indictment in order to be entitled to principal instruction.
Well, but I read the crime was committed by the other person. As to the persons who committed the crime, I believe the evidence in the record is clear. It can only be argued that Luis Rivera and Sequestration Garcia were the actual trigger men, although who may have put them up to the act as a conspiracy, that is for the jury to determine. Any other matters that need to be addressed with 3.5 sub B?
just doing away with the firearm part of it.
That will be omitted.
Your Honor, there's something I wanted to address briefly on 3.5A.
Go ahead.
Am I reading, this is the new instruction?
This is the straight from the Florida Supreme Court on the Florida Bar website instruction.
Well, we are making the affirmative election to use the current instruction rather than the instruction that existed in 2014, which my client would be entitled to request.
This is the current instruction.
I'm sorry, yes.
This is the current instruction.
Yes, we are making the affirmative request for this rather than the old instruction. I want to make that clear for the record.
Moving on to count 2, conspiracy to commit murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, the intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2, as to agreed, conspired, combined, or confederated, which are being requested by the state.
All four.
In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson, Catherine McBanois, and or other persons to cause the first-degree murder to be committed, either by them or one of them or by some other person.
Your Honor, on that, I think I understand the way it is written, but in order to avoid confusion, because the and or would apply between Charles Edison and or Catherine McBanois and or other persons. So I think it could be.
You're just requesting an and or between names.
Yes.
Defense wish to be heard.
Your Honor, I always have a heartburn when I see and or in a jury instruction.
Going back to the indictment, these are the individuals that are within the charging document.
I understand that it's in the indictment. I think it leads to potential confusion with the jury. We would ask that and or not be included.
And if that's the case, then you could put simply or. So and or, my understanding and or are, it can include, basically, if you put something or, it means this one, or this one, or this one, or this one. And so in this case, if it's Charles Adelson or Catherine McBanois or other persons, that would be acceptable to the state.
I don't have a legal objection.
Conjunction?
Yes.
What's your function?
Yeah.
Ooh, love
Very
it.
well, Charles Adelson or Catherine McBanois.
Schoolhouse Rock, shout out.
Persons.
Judge Everett, he knows. Conjunction, what's your function?
It is not necessary that the agreement conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. And lastly, it is not necessary that the defendant do any act in furtherance of the offense conspired. As to the affirmative defense, I'm not aware of any evidence in the record that would require this to be given. Does the defense have any argument?
Yeah, my client still wants to testify.
Legally, Your Honor, there's no evidence of it.
It will be omitted. Count 3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Catherine McBanois, and or other persons to commit first-degree murder. As to this, are the parties asking this to read with the same or that it does for conspiracy to commit?
Yes.
Yes, Your Honor.
Right. Got the wheel all
Crazy.
set up. That was a lot of work without Trace.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Catherine McBanois or
Oh,
other persons.
man,
to
I
commit
hope
first-degree
that's-
murder during the solicitation,
Active shooter, UMass.
which are being requested by the state.
Wait, there's another active shooter? Is that what you just said?
Well, JD said it. I put it up.
Oh my God. What the fuck, man?
Well, the last one at Temple, was it Temple? Or I forget
Yeah,
what-
that was a whatever.
hoaxed.
During the
Hoax.
False alarm.
solicitation, Donna Adelson commanded,
Hoax.
encouraged,
Hoax.
hired, or requested
Hoaxed. Hoax. Correct. Correct.
Charles Adelson or Catherine McBanois or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation. I think the only area.
Go ahead.
I think the only area principle doesn't apply is for conspiracy.
Do you wish for me to move then the 2 principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation to commit murder as they were previously defined. Or do we need to?
The vote?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that. That's not been requested in previous co-defendants trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the 2 instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
The concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter, whether it can be argued that someone is a principal and solicitor.
Thank you.
So he's letting him touch on that
For
tomorrow.
now, we'll just move the 2 instructions to the end of the counts.
So for now, he's going to move him to the end so that the state can.
Clearly stated that conspiracy, it does not apply to the conspiracy count. I think we're all in agreement on.
I can add it, but ultimately, no instruction can be argued as to the defense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor, and that might be a moot point depending on the research that I do later.
Right. So for now, the judge is letting both definitions in for principal and solicitor. He's put it at the end so the state can argue whichever counts they want to apply to. The defense is like, well, no, they shouldn't be allowed to let it apply to the solicitation count. And the judge is giving them time to research that, and they'll touch on it tomorrow.
Now, we'll just add at the bottom the principal theory. Or actually, this instruction does not apply to. I do that for both principal instructions. Right, moving on to intent as a standalone instruction. This is not a standard instruction, but comes from standard jury instruction 13.1 burglary, which gives a definition of intent. This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
The intent instruction then will remain.
We would object, Your Honor.
What is the basis?
The basis is it's not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection and what we get.
Read it for us. We know what it says.
3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
It's probably number 10, I don't know or not, but it's 6, 7, 8, and 9.
Does the defense have any argument for the giving of number 10?
No, Your Honor, we agree.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony? Or misdemeanor involving dishonesty? Whether the state has met its burden of proof, that will remain. To the next set of give as applicables, law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony?
Yes, Your Honor.
What is the requested instruction?
Have it typed out for you. Would you like to
Yes.
provide the copy to the defense? Sorry about the typo in the title. And the certificate of service. All on Mr. Evans.
Right, as to the requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
This moment. I don't have an objection to the first one, but the second one we do.
What is the objection? Is the second?
Your Honor, it's based, the witness's presence in the courtroom is based on our apparent misunderstanding of the discussion that we had at sidebar last week. As a result, we think that the first one is an accurate statement of the law, but under the facts, the second one would be inappropriate.
Kappelman, what is your argument for the giving of the second?
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
Your Honor, it's just dawned on me where you're sticking the previous requested instruction that the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence as opposed to, because
You're asking for those then to be inserted into the tip, or what would be the 9 questions and make it 10?
yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe, disbelieve all or any expert testimony, then was the witness present in the courtroom during the testimony of another witness or witnesses. And so it's hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now. Going back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
Not from the defense, Your Honor.
Those will be admitted. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor, can we go back to the first bracketed language, please?
Which is being requested.
Claims to have helped the defendant commit a crime. I think that would apply to Ms. McManila and to Mr. Rivera.
State.
Second. Stop here. So we're, for the record, as I understand it, of the bracketed languages under accomplices and informants,
Who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
All right.
So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty.
Thanks, Sarah.
There have
She on
been
the
no
wheel?
children witnesses. The defendant has not testified. Witness talk to lawyer. Is either party requesting this?
Yes, Your Honor.
That is a given. And in given all cases, you may rely upon your own conclusion about the credibility of any witness that will be given. Defendant not testifying. This will be given in full.
Dreamy pragmatist. Thank you.
Donna's like, wait. No.
Change the pronouns.
Don't
to
give that. I'm
defendant.
going to testify.
The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement.
No, but
This specifically goes to whether the statement was freely and voluntarily made.
yeah.
As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
Oh, dreamy. Oh, dreamy. Jumping the gun anyway.
Rules for
Like trials.
deliberation. Standard instruction, this will be given. Does either party wish to be heard?
No, sir.
There you are.
Cautionary instruction, does either party wish to be heard?
No, sir.
There you are.
Single defendant, multiple counts, does either party wish to be heard?
A minute of Epstein footage.
I heard about the big
Gots to
ruling
know.
in the Hewerman case.
3.12 verdict. Any objection or request?
I gotta find this thing.
Moving on to the verdict form. Count one, we the jury finds as follows as to count one of the indictment, first degree murder. Check only one letter choice as to this count. Option A, defendant is guilty of first degree murder. Option B, Defendant is guilty of the lesser included offense of second-degree murder. Option C, the defendant is guilty of the lesser included offense of manslaughter. Option D, the defendant is not guilty as to count 1. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option, since she has the presumption of innocence. We would also request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to the first option. That is overruled. As to the
Wait, pause it a sec.
being in bold or not, does the state have a position at which is the raise?
The only thing I would
Dave?
suggest, if we leave them involved, it makes it clearer for the jury.
Yeah.
So is this the minute of when he was supposed to have hung himself? Because there's a lot of people coming and going. Looks like a lot of guards over there. I
Is
mean, I
that
don't-
what came out today?
I have no idea what I'm looking at. So I guess
Yeah, no, like that could be some old shit.
Because that maybe this is outside of his room. No, it's today. I think. Where the heck did it go?
Ooh,
17
Epstein
hours ago.
survivors are compiling their own list of Epstein associates.
There you go.
But they say they're scared for their own safety.
Well,
Hmm.
yeah, no, it's a new video, but what I'm not sure is if the corner that I'm looking at has anything to do with where couldn't be where this happened, because
All right,
it's
let's
like super-
power through. I think he's at the end of the
All
jury
right.
conference.
To differentiate between each of the accounts, but I'm real strong feeling that I see why they would be involved.
So you are requesting for it to remain the same or to not be listed?
I request they remain the same simply because I think it makes it much clearer to the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
Very well. It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count 2, we, the jury, finds as follows: as to count 2 of the indictment, conspiracy to commit murder. Check, only one letter choice as to this count.
Your Honor, what about all caps for the guilty, not guilty words in count 1?
This is stylistic because ultimately this has no bearing on how they're evaluated.
Oh, I get it.
Correct.
I'm looking at that no one went in his door. So
The same reason why I'm asking for the names of the charges to be in regular caps, not all caps throughout the instructions.
I don't know that I buy it.
Same principle.
State, do you have a position?
Your Honor, I think it's, to me, when it comes time to signing the verdict, we want it real clear which boxes they are checking. I think this makes it most clear. That's the reason I think the all caps and the bold are appropriate. The only stylistic change I would suggest, like count 1, probably
It's a little mess.
move the degree murder that's up under it over to fully under subsection B, and manslaughter fully under subsection C. So it's not up under the check box. But other than that, I think
Family hub.
We're going to be asking the same
About an
thing.
hour ago,
As is,
they rested. Level I.
when they're looking at it, you know what you're checking.
As to the body of the instructions, I will grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. 2 options, guilty and not guilty for count 2. Same 2 options for count 3, guilty and not guilty.
Suggest, Your Honor, for count 3 that you move it off page 16 to the top page 17.
I've been making several edits, so my pages aren't the same, but it will flow to where it's not being broken up between pages.
I do not buy that this is an
Closing
unedited
argument
video.
2.7, any
Mm-mm-mm.
objection or request?
Call me a conspiracy theorist. Whatever.
How much time is each party anticipating for their closing argument?
Jurors sent home. Right there. Jury released for the day.
We would say the same, Your Honor.
Very well. Both parties will have 2 hours to present their arguments. Ms. Kappelman, yours will be broken up based on what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2 hours. Submitting the case to jury, just with the time, nothing else. Any objection or request?
No, sir.
Well, Your Honor.
The items that are going to be sent into the jury.
My
room,
client
believe
wants to
we
testify.
have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
Just the demonstratives, Judge, all the exhibits.
A demonstrative is not admitted, so yes, I would agree. It does not go back into the jury room.
Ms. Dugan and I spoke earlier during the trial about going through especially 73 and 73 and make sure it applies to the court's ruling, so we'll do that before you're sent back.
All right, and I will just leave it then. Photographic discs, jump drives, reports, and document exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. And the final instruction, when we reach the end of the case, instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
No, Your Honor.
Believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. Believe the state has requested within 3.5A for manslaughter. It is not necessary for the state to prove the defendant intended the death of Daniel Markel. Believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically asked to count 3?
It's specific, principle applies to count 1. There's not disputing that.
I've had an issue.
I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
All right, once I've made my edits, I will send through my assistant an updated copy of the instructions.
Oh, they're done.
I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow.
We should start at 8:30 just in case.
Yeah, well, we're going to start on time tomorrow, 7:30 our time. That's it, kids. Short of some kind of, like Ali was saying, something insane, like where Donna comes in and just flamethrowers her lawyers saying they misrepresented how much time I'd have. They told me we were going to have witnesses all day. I thought I was going to have until Thursday. They didn't prep me properly. Like they came in and talked to me for a half an hour. I don't like it was this decision that was thrust upon me and I didn't feel prepared to make, you know. If she does something like that, maybe. Short of that, there's no way. Like
I mean, if you're Donna, and a lot of people have been saying in the chat, you get sick overnight.
Yeah.
But you gotta be able to really play sick, you know, like
I mean, but
not
they
move. Don't
they
open your
can
eyes.
they can still conduct it without her being there.
What?
Closing. Yeah.
No, absolutely not.
What?
In absentia when she's got a medical issue?
Yeah, fuck her. Be
don't
like,
know about
fuck
this.
her.
I don't know about this.
I mean, listen. I mean, that's the way it could go. Or
Donna, this is your conscience speaking. You need to fake like you're having a heart attack. That way, you see, they will pause the trial.
So we need to figure out, because it could be mid closing that we are going live with.
okay, now that's not happening.
Damn it, man.
We are not pausing closing argument. And like Austin Drummond shit will wait until that's perfect for jury watch, verdict watch.
We're starting a brand new live for that. So
Really?
yeah, I want
Do
the
you have a-
people that are watching that are following that case. I don't want it to
Do you
just
have a
be like,
thumbnail ready? Do
well,
you have a
Mandy's
thumbnail?
working on it for me because she loves me.
Oh, okay. All right. So we've had the wheel going. We've had a ton of generous people on Venmo today. Today was a great Venmo day.
Venmo Day.
Iceman Cometh came in last, but certainly not least, with 75 big ones on Venmo. Now, I have capped off, I've decided unilaterally without checking with anybody. I do a 10 entry cap. So, which is the equivalent to $50. It's $5 a pop. So I put in 10 for Iceman Cometh. But Danielle and you guys, I say this all the time. If you gift us or donate to us on Venmo and you have a screen name that you don't want us to use your first name only, let me know in the comment that's on Venmo what your screen name is, because otherwise I don't know independently unless I know you. But Danielle came in with a $15 Venmo. Renee came in with a $50 Venmo. Gloria, $5 Venmo. Pamela, $25 Venmo. Dixie, a $5 Venmo. Tammy, $5. Holly Ann, $5. Caitlin, $10. Brian, $10. Chelsea, $10. Christy, $10. You guys were amazing. Thank all of you so much for that. We really, really appreciate it. We also got some PayPals, which sometimes I am not great at checking. But Bobby with an I came in with $40 PayPal. Thank you so much. And she said it was super fun watching Donna Adelson's trial with you two. We appreciate that. Laura.
Yes, we do.
Said, put me on the wheel. Lots of love from Ohio. We appreciate that. And then Charlotte said, love the lives. And thank you so much for that. You guys are all on the wheel, obviously. It doesn't matter where you gift or donate us, wherever it is, it gets you on the wheel. I've worked very, very hard on prepping the wheel during the jury instruction. Thanks, babe. It was a lot. It was a lot of typing. It was for a guy who's not really that great at typing. And just so you all know what you're going to win, it's this giant fat. So you get this, which is actually a little tattoo. You get this sweet, sweet key ring. You get this sweet, shimmery, super cool OG True Crime podcast. You get another shimmery holographic straight dope. You get a straight dope magnet that you can stick in your fridge. You get a straight dope square sticker, a little bit different, pretty cool though. You get a OG, a true crime podcast magnet. You get a true crime sticker, and then our new cover art, which is this, which I love very, very much. That's a sticker. And then Allie and I will autograph this thing, and then we're going to send you a sweet picture of Nook where he puts his little paw print on it because everyone wants a sweet little picture of Nook. So look at Allie's face. She's like, "What?
What are we putting ink on the dog's paw? I mean, did you think
man, I'll figure it out. Don't overthink it. Don't overthink it.
No, Dad's pimping your paw out.
And I forgot this Just Facts, solid Just Facts sticker. So, all right, whoever wins this wheel spin is going to win that fabulous sticker package. So it's very exciting. All right, let's bring it up. Let's bring it up. Stop that one. And share the wheel. Do 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 do. Try to make it a little bigger. If we can fit it on there. Okay. Wowie zowie. Look at that guy. It's packed. See all that typing I had to do? Wow.
Yeah, you did good.
Wow. Just wow. I'm really admiring it. All right, you guys ready for the wheel spin? Oh,
I thought it was going. I was like watching it. I'm like, where's it going to stop?
No, it's just floating. It's floating. I also want to mention that we had 2 people on the last wheel, which was Ashley Lauren and Sherry S. from last Friday.
On this wheel. All right.
On this wheel. So I did not forget. I had taken a picture and I promised I'd put you on. And as promised, I did it. So, all right, let's go. Are we ready?
We're so ready.
Here we go. Wait. Brooklyn's saying check Venmo. Hold on.
Oh, no. Got to add one.
Oh, my God.
You missed somebody.
Oh, Eileen. You got in there at the last second. I'll add you real quick.
Come on, Eileen.
Oh. All right, Eileen. Boop. There she is. You're in there somewhere, Eileen. Tell you, thank you, Eileen. All right, you guys ready for the big spin? Here goes nothing. Round and round it goes. Where it stops, nobody knows. It looks like Kiki Marie.
All right.
Marie, you win the big spin. That goes to show. I think Kiki Marie had 2 entries. So even if you have people with 10 entries, that does not guarantee their win. There you go. So Kiki Marie, we're going to throw the email up here. Give us an address or a P.O. box where we can send your stuff, and keep your eye out on your mailbox. There it is. There's the stream elements. That's where you send it. A true crime pod at gmail.com. So, all right, tomorrow, bright and early.
You took a picture, right, babe?
I did.
Okay.
So tomorrow, bright and early start, 7:30 Central Daylight Time, 8:30 Eastern Daylight Time. God knows what time that is across the pond for all of our beautiful humans that watch us from over there, because we love you guys. And Allie is also just adamant about we're going to cover Austin Drummond tomorrow. He's up in court. It's going to be an interesting case to follow, we believe. We also owe you guys it's
1 o'clock Central Time, SDT, same time as us when I looked it up. So if closings are underway, then we'll do it on a break.
Well, I think closings will be over. So we should be in verdict watch, and we can absolutely
transport
do a new
everybody
live.
over.
Yeah, we'll start a new live because we'll just create a verdict watch, and when the verdict comes in, we'll just start a new live for that.
Plus, you should get on to the verdict watch thing about who we're going to have.
Wait, did they say
Doug's
Doug's saying 2 p.m. Eastern? Is that for Drummond, or is that?
Yeah, Eastern. Yeah, Central. It's 1 o'clock our time.
Okay. All right. So, yeah, that'll be it. And then tomorrow night, Eric Carter Landine is coming on, hanging with me. He's going to tell you about the amazing work he does on behalf of victims and their families.
When's that?
This is an amazing guy. Tomorrow night. tomorrow night. So you guys will, if you've met him, you know him, you love him. If you haven't, you
adorable.
will love him. He's a wonderful human being.
And
He
adorable.
does, yeah, he is adorable, and he does so much for so many people. He's one of my favorite humans. He's
With his
just
sweet,
an
lovable way.
unbelievable guy. Yeah, yeah, he's all the good things. He's
Mhm.
all the good things. All right, y'all. We love you guys so much. Mods, thank you so much for all your hard work. We adore you. We think that you're absolutely magical. Because without you guys, and I mean this.
Wait a minute. We've got
What?
Tracy and Mandy. We got to thank
Oh,
Tracy and Mandy.
I love you. Mandy's been must be real living tonight. And
We're still
Tracy's
thanking
also
her.
doing some real living today. But
They still deserve
Tracy's
our
popped
thanks.
in. Of course they do.
Always.
We love you guys. We love you so much, because without you guys, all of you, I'd just be an old man.
Sitting around talking to his wife.
Boop. See you tomorrow.